Yes.
May I have my lord kind leave my lord to mention item number 320 and 321 of my lord today's list.
Supplementary list.
Supplementary list. My lord, these are appearing otherwise my lord as 3 p.m. matters, custody matters. My lord, I am the
Three?
father. 320, 321. My lord, I just want my lord,
তো mark করে রাখুন তো 320321. Yes.
should I my lord come back at 3 p.m. then?
It's 3 p.m. All right, come at 3 p.m.
So grateful to your lordship.
Yes.
Item 74 is also a custody matter. Lord, I have to hand over the child, Lord, on the next Sunday. So, Lord, if my Lord takes it up
Next Sunday.
that's the today or
Item number
74. So, Lord, on the that day I have to hand over. Lord, whenever my
Deepa Das.
yes,
Tomorrow 3 p.m.
tomorrow 3 p.m.
Tomorrow 3 p.m.
74 tomorrow 3 p.m. I send you notice today.
My lord,
Leave granted to file with the server copy.
my lord,
In absence of the mother, 4 years to file.
Yes. Item number. Item number. Oh, leave, please. Leave. Do you have the server copy? Certificate copy, all right. Leave.
Number 77.
77, yes. What do you want?
My Lord. The order transmitted last Friday.
3 p.m. 77.
78.
If your lordship can takes it up today, my Lord.
Today it's not possible.
my lord,
No, 3 p.m. no. Because it is to be listed.
my lord, may I be
Yes. 77 tomorrow 3 p.m.
77
tomorrow 3 p.m.
Day after tomorrow is the day. 77. 78.
78 tomorrow 3 p.m. 78 tomorrow 3 p.m.
Very urgent. It cannot be wait till tomorrow also.
Why? What's the urgency?
20th, the order has been passed by directing the mother along with the son to stay at the matrimonial home for entire Puja vacation. And this is the order on 26th.
Have you filed it?
20th order passed. Today is the first date. I can avail this opportunity.
But
Today,
supplementary list today 2 p.m.
my lord, may I be permitted to mention item numbers?
Please wait. Yes.
order দিয়ে দিয়েছি।
You want leave to file tomorrow. What a leave to file tomorrow. To appear tomorrow. Yes. Leave to file without certified copy.
With your lordship permission.
Sir, please don't say top of the list. Yes.
With your lordship permission, my lord, CO 3523 of 25, my lord, the matter was taken up before your lordship on 22nd of the Monday. That is Monday, my lord. My lord, you have directed to give it in the monthly list in the month of December, my lord. The
Yes.
grievance is that the filing for the amendment petition in the civil junior division Ullu area is given last
Mention
chance.
after the vacation.
My lord, the last chance is given, otherwise it will be dismissed, my lord. Kindly fix it today at
What is the next date fixed?
29/10/25, my lord.
29?
October
All
2025.
right, please come.
My lord, the direction has been given from the civil judge senior division that it will be dismissed.
Why did it not appear on 22nd?
My lord, I have appeared, my lord. You have directed to give it in the monthly list of
Why it
December.
was directed to appear in the monthly list?
To serve the notice to the opposite party, my
Serve the
lord.
notice. Yes, that is why.
My lord.
Yes.
Item number 69 last permission.
Yes. Hand over the slip. Yes.
But may I have your lordship kind leave to file this matter without certified copy and without the copy of the order?
You
Because
don't have the server
no, my
copy.
lord, this
Why?
is extraneous circumstances, my lord. The superintendent of police GRPS, my lord, Kharagpur railway station was summoned by the railway claims tribunal.
Yes.
No order was served. Only this was served upon them, my lord. Only this copy, my lord, of the summons was
Leave to
served.
file.
The matter, my
Grateful, my
But
lord.
what is the order? Have you?
Yes, my lord. I have indicated. I have not got the certified copy. That is also
No,
indicated.
what was the order? Where have you indicated that?
My lord, I have indicated in the paragraph. In the paragraph, my lord, may it be placed in the supplementary list today because
Not today.
no. The order that has been passed and the summons that has been issued uh, directs and obliges me to be present tomorrow with the documents personally.
No, তাহলে
Yes,
ওটা-
my lord.
ওটা supplementary list
10:30
today.
tomorrow.
Supplementary list today,
Very well,
tomorrow.
my lord.
Yes.
Grateful.
File the matter, my lord. I have the certified copy, my lord. Under compelling circumstances, I am paying before your lordship, please, my lord. In a title suit, my lord.
No, what do you want?
My lord, kindly fix it on tomorrow or day after tomorrow, any day, my lord.
Tomorrow.
May
I have your
inclusion in the list.
Do not wait till after the vacation. Before this vacation, only 2 working days left. Please come after the vacation.
May I have your lordship's kind leave to mention item number 106 of your lordship's list, mat. The
Yes.
next date before the learned court below is tomorrow, if it can be taken up, my lord. The urgency, my lord, will kindly, this is for administration of a society, my lord.
Sorry,
So, my lord, the election,
Nothing will happen.
election, my lord.
Groups are fighting, nothing will happen.
I had made an application for modification of the earlier order on the ground that
Yes.
the learned court below has said that the voting will continue.
Let it continue.
Do not have the eligibility to be members.
That will happen. Let the voting continue.
To file the matter, my lord, I have been denied visitation rights of my child, my lord.
Yes.
My lord, to mention matter for extension. I have mentioned it previously.
My lord,
But this has not come up in the list. My
extension.
My lord,
interim order is
item number 49 tomorrow 3 p.m. My lord. Item number
One urgency.
now the urgency is that matter is fixed. Item number 49, my lord, new motion. My lord, duration passed by the honorable division bench upon the defendant to file written objection within a stipulated time. My lord, that was not presented.
That's not the urgency. Yes.
that matter could be fixed tomorrow or day after because I
Yes.
mentioned it.
Extension.
Yes, your lord.
Yes.
My lordship, may I have your kind leave to mention this matter, my lordship? The ground for urgency is that my application is still pending before your lordship and the date has been fixed on 31st October before the learned civil judge junior division Alipur lordship. May it be taken up on the reopening or after.
Yes, on the list.
Item number 1.
Lordship, and
33 রিভিশন 33/78/2025 ওয়ার্ড কোর্টে 1/11/25 পজিটিভলি আমাকে স্টেটা নিয়ে
All right. Please,
সাল 24/25
it will appear after the vacation.
ঠিক আছে
Yes.
My lord, I have filed the CAM for expert hearing, interim order for expert hearing stay.
Over the slip. Yes.
Lordship, item number 1, I am appearing on the instruction for the petitioner.
Yes.
Today
can
was
can
fixed
file-
handing over of the written notes, but then the advocate on record is severely ill due to the viral. Lordship will kindly fix it on Friday. It will take 1 minute. I will personally come and hand over.
Friday date বলে লিখে রাখুন, কিছু করতে হবে না। Friday date.
Obliged.
Yes, next.
Obliged.
Item number 2. 2, yes. 2, who is appearing?
But I am for the petitioner, my lord.
Yes.
Ultimately, my lord, all the belongings that has been taken away, my lord, on that very day, within the time as prescribed by your lordship, a formal, my lord, report, as my lord suggested by your lordship, is being.
I think joint special officer.
Special officer of both
This
the
is the
affidavit of record.
joint report.
joint report.
আসুন। Item number 4.
For my lord, in this matter, my lord, I am appealing for the petitioner.
Yes, what is
My lord,
this?
in item 3, I was appearing, my lord, for the opposite party.
Uh,
My lord,
come tomorrow because the affidavit of compliance is not ready.
my lord, may I just indicate something in item number 3?
Come
Because
tomorrow. Please
my lord,
come.
then my lord kindly keeps it after the vacation, my lord, because I am indisposed tomorrow. My lord keeps it after the vacation, my lord. I just request your lordship.
No, tomorrow they will file complaints report. Ask any one of your friends to appear. Yes, yes, Mr. Rai.
This is relating to the election petition. It was argued by the disqualification of the.
So I am for the State Election Commission led by Ms. Sinha. Your Lordship, in this matter, there is a maintainability issue because the election petition is usually governed under original side election petition. So when he is challenging the election petition, as per statutory provision, whether it is maintainable under 227 or not, it is required to be heard. Lordship, she is arguing one matter in court number 24, Your Lordship.
Probably my learned friend is arguing regarding the state election representation of the People Act, where the MLA and the MPs, they are the subject matter jurisdiction before the Honorable High Court representing.
Yes.
Now, my lord, can you consider what is the case made out? Can you turn to the internal page 6 of the order impugned? The learned advocate for the petitioner has referred to documentary evidence. My lord, got it.
The learned, yes.
Documentary evidence submitted to Exhibit 1. It has been clearly mentioned that the work order being number such and such referred to NIT number.
Yes, this was whether that work
Yes.
order. Yes, Mr. Banerjee, what is your instruction?
Yes, this is.
Yesterday, my lord, in this situation.
Tomorrow,
My lord, I've got the work order. And
Mr. Rai, he has to take instructions.
Applications, the replies have been.
Come tomorrow. Mr. Rai, please give me the copies what you have.
Immediately reopening, my lord.
my lord, I'm praying for the already vacation has been declared.
Yes.
Then the
Please
representation
come
of the
tomorrow. Tomorrow, yes. Ashun, heard Mr. Rai, learned advocate for the petitioner. Mr. Banerjee. Item number 5.
My lord, item number 5, my lord, may I have your lordship's leave to appear virtually, my lord?
Yes, yes.
I appear for the opposite
This is
party.
the affidavit of service, my lord. I have served, my lord.
You are for the petitioner.
Petitioner, right?
But I
Yes.
appear for the opposite party.
Yes, Mr. Chaudhary, what do you say?
My lord, the marriage was never consummated. My lord, I was praying for a decree under such circumstances of nullity, my lord. I have also filed my written statement as well as my evidence.
So, but you did not appear before the learned trial judge.
No,
Why?
no, but I had filed my written statement before the learned court, my lord.
But you did not appear on that date. When
But
the
lastly, my lord, this order was passed in, my lord, 13th of August 2025. The hearing concluded 1 year ahead, my lord. In the year 2024, the hearing was concluded.
The last. Yeah.
Oh. Order passed after 1 year.
Yes, my lord.
Application was heard 1 year back.
3rd of April, the application was heard.
Directing the learned trial judge to reconsider that application. Ashun. This application under Article 227 of the Constitution of India is at the instance of the wife and is directed against an order being number 14 dated August 13, 2025, passed by the learned Additional District Judge First Track Court at Baripur District 24 Parganas South. By the order impugned, 24 Parganas South in where is the number of the matrimonial suit? In matrimonial suit number 665 of 2023. By the order impugned, the application under Order 12 Rule 6 of the Code of Civil Procedure stood rejected. Mr. Dolapati, learned advocate, appearing for the wife petitioner, submits that the marriage between the parties was not consummated, and for such reason the petitioner filed a suit for declaration that the marriage is a nullity. Full stop. He further submits that the opposite party husband has filed the written statement, admitted the fact that there had been no consummation of marriage. Full stop. The learned advocates for the respective parties uniformly submit that the application under Order 12 Rule 6 of the Code of Civil Procedure was heard more than a year back, and was heard long time back, and the order on such application was filed after more than a year of such hearing. First of all, for such reason, this court is inclined to set aside the order impugned. First of the application under Order 12 Rule 6 of the Code of Civil Procedure is stands restored to the file of the learned additional district judge, First Track Court, Baripur. First up, the learned additional district judge, First Track Court, Baripur, is requested to reconsider the said application and to decide the same afresh after giving an opportunity of hearing to the respective parties. First up, with the above observations, CO number such and such stands disposed.
Within a certain period.
Within a period of what is the next date fixed?
Lord, next date fixed on 11th of November 25.
As expeditiously as possible, but positively within a year, but positively within a period of 6 weeks from the next date fixed.
My lord. Grateful, my lord.
Yes, next.
Grateful, madam.
Lord, 6 weeks from the date of
From the next date fixed. Next date is the 11th of November.
yes, 4 weeks, my lord, 4 weeks. From the next date fixed, my lord, after vacation, the next date.
Has to be after vacation. Only 2 days left. Yes, who is appearing?
For the petition.
Lord, I appear on behalf of the opposite party.
But interim order. My
Chakraborty is appearing in the trial mode.
Since I'm not inclined to take
My lord, I am appearing for the petitioner. My lord, time to time, your lordship has been kind enough to extend the interim order. There was a direction of affidavit. My learned friend has already, my lord, served a copy of the opposition. I have thought I am filing the copy of the reply, my lord. Kindly extend and fix any date, my lord, after vacation.
when have you filed the opposition?
Position was filed long back, my lord.
Long back. The affidavit in reply filed in court.
That will be appearing under assignment.
Assigned matters. It was assigned. Oh, the list this matter under the heading assigned matters.
Deeply obliged.
Yes.
Your Lordship, I appear for the petition. This is not a service.
What happened, Mr. Bordon? You are not.
Opposite.
Yes.
Sir, I have got motions.
This. After hearing the learned advocates for the respective parties, the interim order is extended till the end of the month of February 20.
I for the petitioner. But this interim order was extended on.
My lord, I am for the opposite party, my lord. On earlier occasion, I also appeared before this honorable court, my lord, in respect of the said present case.
All right. After
My
hearing
lord,
learned advocates for the respective parties,
yes.
the
My
interim
lord,
order.
my lord, my submission is this, my lord.
Yes.
Kindly fix up a date, my lord, for hearing. A short
Sir,
date may kindly
appear-
fix. My
it will
lord,
appear
a
after
short
the
date.
petition.
Short-
After hearing the learned advocates for the respective parties, the interim order is extended till the end of the month of February 2026 or until
My
further
lord, February, my lord, high time, my lord, kindly see, my lord, it's a very long date, my lord. A short date may kindly be given, my lord.
earlier. List this matter under the heading contested application 4 weeks after reopening of this court after Puja vacation. Yes, call the next matter.
Highly obliged, sir.
Yes, call the next matter.
Item number 10, my lord, I appear on behalf of the petitioner, my lord.
Yes.
This is my evidence.
Mr. Chakraborty, you are for the opposite party.
My lord,
Uh,
a date may be fixed.
After hearing the learned advocates for the respective every service file is taken on record, the opposite. Yes.
I am for the opposite party, my lord.
Yes, after hearing every service filed in court today is taken on record after hearing the learned advocates for the respect.
For the petitioner, my lord,
Yes.
for extension of interim order, my lord.
Have you served?
My lord, I have served, my lord.
The learned advocate appealing for the petition submits that the opposite parties have been duly served. Every service filed in court today is taken on record.
My lord, the interim order is expiring today.
Today,
Today, my lord.
not today, this month.
End of this month, my lord. In fact, it is more or less.
Have you served?
My lord, that affidavit service is there.
Every service filed in court today is taken on record. The learned advocate appealing for the petition submits that the opposite. Call the next matter.
Item number 14.
Yes.
Item number 14, my lord, I for the petitioner.
Yes,
I
Mr.
appear
Ghosh.
for the opposite party, my lord.
Yes.
The preemption matter.
Preemption, what is the issue?
But they say that, Lord, that two of the judgments of this honorable court was not considered concerning, Lord, the preemption.
Adjoining owner.
Yes. Adjoining order.
Longest boundary, whether it has to be partitioned or not.
That is one of the issues.
Lord Kundu is.
But we need to, Lord, argue on this.
All right, I am extending this.
Yes, because in both the courts below, Lord, I won. Very well, my lord. Your lordship kindly extend and, Lord, let it be in the list.
There are two matters, my lord. Other issues, Mr. Mukherjee, any of the issues which is pending before the larger bench is there. If
Lord,
that
on
is
this,
so,
Lord,
this matter, any of the issues, entire share or the Bastu or
not to my knowledge, Lord, but I'll try to, Lord.
no, if that is so, it cannot be taken up. That is why I am saying.
No, my lord. As far as I know, Lord, there is none, but I'll ask Mr. Partho Pratim Rai, Lord, he must be there in any of the matters. Can he extend and fix the matter after the vacation, my lord?
Every service filed in court today is taken on record. Mr. Mukherjee, learned senior advocate, appears for the opposite party. First, Mr. Ghosh, learned advocate, appearing for the petitioner, prays for extension of interim order First up, such prayer is seriously opposed by Mr. Mukherjee, learned senior advocate for the opposite party. First, however, after considering the submissions of the learned advocates for the respective parties, the interim order is extended till the end of the month of February 2026 or until further orders, whichever is
Same order in the next matter.
same order, next matter.
This is the same order, Malad. This is affidavit service on the next matter.
Same order, next matter. Yes, call the next matter.
Item number 16.
Yes.
The respondent in this matter, my lord.
My lord, we are for the petitioner. We have served the other side, my lord.
Yes.
My affidavit of service may be taken on record.
Worship, this is challenging an order of cancellation of a conciliation proceedings before the MSME, lordship.
Yes,
It's a very small point, lordship, and
cannot be heard now. It's appearing in the list under the heading motion.
yes, it's appear. The only difficulty is, lordship, I am suffering this order, so let it be fixed at an early date after the vacation,
Yes,
lordship. That
it will retain its position in the list. After hearing the affidavit service filing.
on behalf of the petitioner.
Yes.
Affidavit of service.
Affidavit service filed in court today is taken on record.
Item number 18.
Yes.
So the affidavit of service, other
Yes.
side is the
Lordship, the seat of arbitration in this matter is in Bhubaneswar. As it is, this matter does not lie here. Anyways, your Lordship, my only prayer would be the council comes from Delhi. So only if a date may be fixed, your Lordship, that is the only request.
Please mention after the vacation, I can fix it after the vacation. The affidavit service filed in court today is taken on record. Full stop. The opposite party is represented by its learned advocate. Full stop. After hearing the learned advocates for the respective parties, the interim order is extended till the end of the month of December 2025 or until further orders, whichever is earlier. Let the matter retain its position in the list under the heading motion. It's
Much
appearing in the list.
Yeah, sure.
Yes.
Deeply
Please mention after the vacation.
Much obliged.
Yes, call the list.
Item number 19.
Yes. Yes.
I am appearing for the opposite party.
Yes. Who is for the petitioner? Who is for the petitioner?
Some Ayan Chakrabarti is appearing for the petitioner.
And appears for the petitioner at the time of call. No. Call the next matter.
Item number 20.
I am for the opposite party.
Opposite party, who is for the petitioner? This judicial application is the abuse of process of law. This one appears for the petition at the time of call. No accommodation has been sought for either. In view thereof, CO number such and such stands dismissed for default. Yes, call the next matter.
Item number 21.
Yes.
My lord, I am for the defendant petitioner, my lord.
Yes.
Plaintiff filed suit stating that Sibratan Koyal was the tenant and he died, my lord, as per section 2, my lord, applicable to him, my lord. My defense is that Sibratan Koyal died long back and the suit is not maintainable. My lord, the evidence of the DW1 was closed on 24th of July 25. Thereafter, my lord, date was fixed on 29th of August 2025 for DW2. My lord, on that date, my lord, one date I took, my lord. One date because the death certificate, my lord, could not be made available. But on the next date, my lord.
Death certificate of whom?
Death certificate of Sibratan Koyal, who according
is it relevant, Mr. Chakraborty?
According to the plaintiff, he was the original tenant.
Yes.
And my lord, if the death is made may happen, my lord, before the 2001 Act, then my lord, this act will not be applicable. I produced the my lord. Kindly see, I have got the death certificate only on my lord 17th
No,
of
Mr.
one date I have taken. One date.
Show me the plaint.
Yes. My lord, kindly see.
Died long before.
Yes.
Paragraph been extinguished.
Paragraph 2, there is the plaint. My paragraph 2, he has stated Sibratan Koyal. My lord, I have stated in, my lord, kindly see page 22, that is the written statement. My lord, in the written statement, I have stated, my lord, the kindly see page 22. In the written statement, I have stated, my lord, Sibratan Koyal died long back and Sibratan Koyal was neither residing there and occupying the flat. This is my positive defense. And my lord, kindly see one date I have taken and when I have got the death certificate. My lord, kindly see that page 47. Page 47 is the death certificate. Your lordship will get.
Where is the evidence of DW1?
Yes, my lord. I have stated, my lord, DW1 evidence, my lord, I am showing.
Who are you?
My lord, I am the DW2. My lord, I am, according to me, I am the tenant. My lord, I am all along making payment of rent. Sibratan was not the tenant. This is my case. My lord,
you are the defendant number?
I am the only defendant.
Yes. You have deposed, Mr. Chakraborty.
My lord.
You have deposed. You have deposed DW1.
You have deposed, but the death certificate was not with me, my lord.
Yes.
The death certificate after my deposition is made, I have obtained, my lord. Nowadays, my lord.
Why the death certificate was not with you?
My lord,
he was your father.
No, my lord. He was not my father.
What is the relation between Sibratan and you?
He is my lord, a distant relationship. My lord, not my father. And my lord, the corporation do not provide. My lord,
Mr. Chakraborty, your case was that Sibratan was not the tenant and you are the tenant.
I am the tenant.
So you have for proving such fact you have made your
well, jurisdiction will be that the filing of the suit if somebody tenancy.
Mr.
My lord, relevancy, my lord, kindly see examination. One date I have taken.
Mr. Chakraborty,
and that I file application for recall. That has been dismissed.
Yes, Mr. Chakraborty, there is one thing. I have to see whether the evidence of that person is necessary or not.
Yes.
Because here, your positive case is that you are the tenant. You have laid all your evidence proof.
Not only that,
yes.
my lord, I all along.
It is the plaintiff's case that Sibratan was the tenant and he died long back. Plaintiff has to prove. You do not have any obligation to prove. It is your case that you are the tenant and not Sibratan.
Plaintiff has stated so in the way. My lord, if
he does not, if he cannot prove that, I am trying to prove his case.
No.
If he cannot prove his case,
no, my lord, my lord, it is my written statement case. My lord, it is the case in the written statement, my lord.
What is the case in your written statement?
My lord, kindly see.
It is denied.
No. Also,
Yes,
Malo, my
it is
kind-
denied that Shivratan Koyal was the recorded tenant.
kind
If
of-
that is so,
Malo,
his death
paragraph 10
certificate is not necessary.
Paragraph 10, with regard to the statement
Yes.
made in paragraph 2, it is denied that Shivratan Koyal was
If
the
that is
recorded.
so,
Yes.
Mr. Chakraborty, if that is your specific case,
Yes.
then you did not, death certificate is not necessary.
Malo,
This
Malo,
application
Malo,
is not
kindly
necessary.
let me opportunity, give me opportunity to
Mr.
produce-
Chakraborty, only for the purpose of proving the death certificate, that is not necessary in view of the defense case. This
No,
application.
Malo, my death certificate to be considered, my lord.
No. It's not necessary in view of
2G or the 2G case applies.
2G. Mr. Chakraborty, please consider it's the plaintiff's case of 2G.
Yes.
Plaintiff's case is that Shivratan was the tenant.
Yes.
So after his death, in view of 2G, you have become a trespasser.
My lord, if
Please allow me to make
no,
my
sorry,
observation.
sorry.
So after his death, you have become trespassers under 2G.
Yes.
But on the other hand, your positive case is that Shivratan was nowhere. He was not the tenant. You had the tenant. So you have proved your case that you had the tenant.
My
So
lord,
death
my lord,
certificate is
kindly
not
tell-
necessary.
If my lord, as a DW1, if I would produce the death certificate,
necessary.
whether it would have been rejected or
Not necessary in view of your specific defense case, Mr. Chakraborty, you have to prove your positive case. Your case is that Shivratan was not the tenant. Maybe a
death certificate is a public document, my lord.
It becomes irrelevant.
It is to be considered, my lord. Death certificate is a public document.
Mr. Chakraborty, if you make those, I have to make all those observations. Death becomes irrelevant. You have to prove your own case.
No, my lord, kindly consider, my lord.
Here it is not necessary. This application under Article 2
22.
Yes.
My lord, item number 22 and 23. These are my lord, connected matters. My lord, I would be humbly praying for an adjournment, my lord, in this matter.
Please don't pray for adjournment. Please move this matter.
Because I'm being led by Mr. Shotapoto Chakraborty. He's not here, your lordship.
You are led by?
Mr. Chakraborty, Shotapoto Chakraborty. He's not
Yes,
here.
yes. What is this matter?
My lord,
You are moving matters. You may be led by someone. Yes, please start. Yes, yes, yes.
My lord, in this matter, I will kindly direct him to serve the copy.
Yes, let me see what is there. Yes, please move, please move.
my lord, your lordship kindly comes to the impugn order first. Your lordship,
Yes.
my lord, this is the number order. This indicate. My lord, order number 102.
Yes.
102, your lordship will find that.
What is the nature of the impugned order?
My lord, impugned order is, your lordship, there was an application for substitution, my lord, on behalf of the respondent number 2. He passed away. It was filed belatedly, your lordship, and we are contending that the matter has abated. And accordingly, but it was allowed, and challenging the same, my lord, we have come up with your lordship. So, my lord, kindly.
When did he die?
My lord.
And when the application was filed?
My lord, he died in the year 2023.
What is the date?
20th November 2023, my lord.
20th November or 11th of September?
My lord.
Borendranath Ghosh.
Borendranath Ghosh, my lord.
So it's the respondent number 4.
Respondent number 4, my lord. Without
died on
word information and the
died on
20th November, my lord.
No, 11th of September.
11th of September. Yes, yes. My lord, my lord.
Is on 20th of November.
My lord.
Yes, when the application was filed.
Lord, kindly gives me a moment, your lordship, right? In just speak.
Opportunity to serve my copy. I'll reply all the things.
We'll be getting. Let me see if you can cross the first hurdle. Please wait. Yes. When did you file?
Let a moment, your lordship. I'll just indicate. My lord, on February 8, 2024.
February
8, 2024. My lord will find from paragraph number 5.
Yes. The years were already on record.
Kindly directs for an opposition.
This application under
Because Mr. Chakraborty is leading.
years are already on record. This application under Article 227 of
wanted to, my lord,
ask him to come. If you can.
Not in town, my lord.
All right.
Keeps it any day after the vacation, my lord.
This application under Please give him copies
I'll just.
in course of this day.
Yes, ma'am.
Yes, next.
Item number 24.
Lordship.
Yes, yes.
Item 19. Display board is not working there, that's why I made a mistake. Display board is not working outside, that's why I made.
Report not working. Bring your other side. Order 21 to 97.
Item number 19.
19. Yes. What is the impugned order?
Order.
Order 21 to 97 disposed of. It's not a revisable.
I'm not aware of the case. My senior is
Your senior to come. Yes.
senior is out of station. My lord, please fix this matter.
Possession has been taken. Please take instructions from your senior and then come bring the other side. Yes. Because other side was present. Yes. Yes, yes. Who is appearing? Item number?
25.
Yes.
24.
24.
24. 24.
Sir, we say, my lord, this is a commercial dispute. And the specified value, my lord, is the valuation of the property.
Order that when rule for disposed of, Mr. Chatterjee.
Along with one.
No, there is challenging.
Application under 151, where we said below that this is a commercial dispute.
But it has not been where it has not been disposed of. Show where, how it has been disposed of.
Takes up the impugned order, my lord.
Yes. Impugned order is order dated 14th of August 2025. Is it the impugned order?
No.
That is not impugned order.
Just give me one minute. 14th August, order number 15. Order number 15.
Yes, I'm saying that.
Yes. Then can you see the valuation thing, my lord?
No, show me how this, where this application, how this application was disposed of.
My lord, kindly takes up internal page. Page 4. 4.
Internal page 4 of the impugned order.
Internal page 4. Oh. ভুলভাল জায়গায় দেখছেন তাড়াহুড়ো করছেন কেন যাচ্ছে আমি বুঝতে পারছি না but this is the kindly see the last
Only
page.
2 days left, Mr. Chatterjee. And yesterday was my fault.
No, not lordship's fault, my lord. Yesterday, even till my chamber, my lord, water was inside.
So one day,
your
one
lordship's
working
case,
day has been lost. That is why I'm trying. Yes, yes.
Then, my lord, this will take a little bit of time. I'll come back after the vacation.
Yes, but
I am
for me.
Yes,
But
kindly sees the last part of the order, which
yes.
Till then, the application under 151 filed by the defendant for dismissal of the present suit is seemed to be premature. And I
Yes.
am of the view that the said application will be reopened.
Yes,
after-
wanted the valuation report to be obtained. It has not been disposed of, Mr. Chatterjee. And you have challenged that.
Then, thus the application under order 39
Fix approval for filing the valuation of the suit
and all
property.
151 are disposed of accordingly.
No, that is order that rule 4 with section 151.
And also the application under 151. That could not happen.
And the valuation report I have filed.
As per the above discussion.
Yes. Thus, the application filed under Order 39 Rule 4 and also the application under 151 are disposed of accordingly as per the above discussion.
So, no, it says, Mr. Chatterjee, because I am of the view that please see the earlier paragraph.
My lord.
The application
I am
will
of
be
the view that
reopened.
the said application will be reopened.
Reopened. So that's the observation.
No, no.
So I'm clarifying that it says
That cannot happen. My lord,
it has been reopened. That is why disposed of the learned trial judge.
I have
Reopened.
given the report. The report is with.
I give you liberty to file that application.
My lord, it again, my lord,
Why?
There'll be delay. My lord.
No.
This is the
No delay.
landlords.
Mr. Chatterjee, because the learned trial judge has to take a call on that.
My lord, the report is before the trial court. Kindly have a look.
Let
at
the
it.
trial court, yes, 18th of December was for filing the valuation of the suit property, the report.
Has been done. Have a look at it. The paragraph above it.
Yes.
Accordingly, the plaintiff is directed to submit report about the valuation of the suit property by the date fixed.
Yes.
And I
Date
have
fixed
done
is
so.
18th of December
I
2025.
have done it.
You are the plaintiff.
Yes.
So it will be.
I'm sorry.
You are the defendant, Mr. Chatterjee.
The landlord.
Yes.
Here is
So
a-
whatever you may be, so 18th of December on that date, the report was directed to be filed.
So
It
that
will be
delays the
considered.
matter. That
I'm
delays-
clarifying
I
that.
filed it.
You have filed it, the plaintiff also have to file.
Doesn't, it is from the government's thing. Same authority, nothing different. The authority can't give something else.
It will be considered on 18th
But
of
there
December.
is no point.
Otherwise, Mr. Chatterjee, it will be kept pending here. That is the
Your
difficulty.
Lordship keeps it pending here, I don't have a problem. But I will, what happens is, again, if I go back, again, there will be another round after.
Mr. Chatterjee, valuation issue has to be decided.
Decide, that's what I'm saying. Decide.
If it is decided, it will be a separate cause of action.
The judge is saying that this application is going to decide later, after getting the report.
Yes.
Has disposed it off.
That is, I am
And
clarifying.
keeps this application pending.
Which application?
This application.
Substitution.
The application under 151 pending. Only to that effect.
Mr. Chatterjee, there are two ways of looking at it. If I have to modify with that, then I have to serve, I have to direct. Other way around, I can take.
Why I'm saying is,
I give you that application.
There will be an opposition. Again, there will be an opposition. Again, there will be a hearing. Kindly appreciates that. I will serve and come back, and I will only pray for that liberty before your Lordship.
Ashun, this
My lord, in respect of item number 20, my lord, Mr. Ritendra Banerjee is appearing for the petitioner, my lord. Your lordship has directed as dismissed for default, my lord. My lord,
Ritendra Banerjee for the petitioner.
for the
Bring him.
my lord, my lord.
Ask him to come. Yes.
25 I appear for the opposite
Well,
party claim.
25 petitioner Mr. Sumitra is suffering fever. So kindly.
But the
write
matter
on-
arises out of a decree, my lord, allowing an section 6 of the specific relief act.
Section 6 of the specific Relief Act. Yes.
Allow. That I am the plaintiff. That I am opposing it.
Yes. No, what is your point? Not maintainable, you are saying.
No, not. I am not. Let them place first.
Yes. Yes. What do you want?
Adjourn for
On the prayer of the learned advocate appearing for the petition. Next.
Number 26.
You have been served with a copy.
I am the caveat.
Yes, yes.
Item number 26, my lord, the connected matter is pending before your lordship, my lord. That is CO number 433 of 2025, my lord. May I pray, let both the matter appear together, my lord. In the
What is this
meantime-
matter? What is this matter?
Now, in this matter, my lord, what has happened, my lord, I am for the wife as well as for the son, my lord. By the order dated, impugn order dated 29/7/2022, my lord, the learned judge has given maintenance to the son, but has not given any maintenance to the wife. And secondly, has started a perjury case against the wife, my lord. We have challenged that order also. And before that, my lord, there's another matter which is pending. We have challenged the entire proceeding itself is bad because we had a reciprocate agreement with the Singapore court. Singapore court has already given us maintenance, which was recorded over here, my lord. So both the applications should be the correct.
Who is appearing for the other side?
Yeah. My lord, we shall serve in command. There's no.
Petitioner is entitled to serve a copy of this application.
Has kept the matter on.
That matter is appearing under what heading?
Listed motion. Listed motion, my lord.
Listed motion. Along with that means it will appear on that date. Along with under the heading listed motion kore din. Along with that.
I'm grateful, my lord.
Call the next matter.
Number 27.
My lord, I am for the
27, yes.
petitioner plaintiff, my lord. My lord, in connection with the suit, my lord, application for amendment was allowed, and my lord, 30th of June was the date. 2025 was the date fixed for filing amended plaint. Well, that was not filed, my lord. On that date, instead of my lord rejecting the amendment application, my lord, that suit has been dismissed for non-compliance of the court's order. Therefore, thereafter, my application under Order 9, Rule 4 was filed, my lord. That was dismissed by the impugn order, my lord. My lord,
Order 9, Rule 4 dismissed.
Dismissed. Lord, if allowed, my lord, otherwise, my lord.
Huh?
My lord, appeal does not lie, my lord.
No. Appeal does not lie. No, why it was dismissed? Is it under Rule 2 or Rule 3? Order 9, Rule 4 dismissal can be only under Rule 2 and Rule 3, where the summons is not served or the plaintiff does not appear.
Here dismissed for non-compliance of the court's order regarding, my lord, submission of the, my lord.
Show me the order of dismissal.
Yes, my lord. Kindly see the impugn order number 67.
6th of September.
6th of September.
You were absent on call on 9th of April.
No, I was present, my lord.
No. It says on both sides 9th of April, you were absent on call.
Yes.
The other side was.
No. Thereafter, no. Thereafter.
No. Other side entered appearance.
Entered appearance. On that date, particular date, no, my lord, other side was not there.
You filed an application under Order 9, Rule 4.
Yes,
No, where is the order of dismissal?
My lord, dismissal order, my lord, is not there, my lord, but it is, my lord, reflection will your.
Sir, Chakravarti, you have made the mistake. Why did you file Order 9, Rule 4?
Certified copy obtained, my lord, but that is missing, my lord. Kindly see page 88, the certified copy Your lordship will, but thereafter one order is there, that is that has not been obtained, my lord. Page 88. Page 88 is the, my lord, order, and thereafter, my lord, the court has stated, my lord, what is the reason for
Yes,
this.
page 88 is the order of dismissal.
No, that is not the dismissal order.
Yes.
Page 88.
To show,
Yes.
as
page
to why that was to file show cause.
None appeared for both sides on repeated call. It now, the plaintiff is.
Where is the order dated 30th of June?
That order is not there, my lord. My lord, thereafter, my lord, your lordship will get the reflection from the order numbers, order impugned, my lord. 6 of 9, my lord, entire order has been, my lord. Your lordship will find that. On perusal of the record, my lord, I find that application for amendment was allowed in title suit number order, the void order plaintiff was directed to file amended plain. Since then, plaintiff has not filed the amended plain on 9/4/2025. Both sides were absent on call. Court was directed plaintiff show cause why the suit shall not be dismissed for non-pursuance of the court's order. Next date, that is on 30th of June 25, plaintiff
By
has
the order impugned.
Yes.
Order 9 rule 4 rightly held. There is no.
What is the correct procedure? I cannot.
That I cannot advise
Hello,
from
hello,
that. Mr. Chakraborty, I have lost that capacity.
Kindly hear me. Kindly. If your lordship will hurry, let it be after vacation.
Not hurry, please show me
My lord,
that this provision is.
My lord,
Mr. Chakraborty, please see order 9 rule
has
4.
been dismissed for non-compliance of the order. Yes.
Yes.
My lord, that has.
Please see order 9 rule 4.
What order, my lord? My amended plain has not been filed. That's why, my lord, my suit cannot be dismissed, first of all.
Why did you file order 9 rule 4? Please see order 9 rule 4 once.
My lord,
That is why I was looking at order 9 rule 4.
My lord, if the suit is suit dismissed, it is not a degree. There is no provision for appeal. Order section 2, my lord, determines is not a final determination of.
Show me, Mr. Chakraborty, show me.
What is the remedy available?
I do not know. Please show me that order 9 rule 4 is maintainable. Please show me from the Code of Civil Procedure.
My lord,
show me.
It was dismissed for default. Default.
Mr. Chakraborty, you are not looking at Civil Procedure Code. That's the problem. You might be knowing the provisions.
I fail to my lord, find out any other problem, other solution.
For that, order 9 rule 4. Order 9 rule 4 is very specific. If it is under order 9 rule 2 or order 9 rule 3,
whatever maybe
that's the Mr. Chakraborty, that is the specific finding.
Whatever
may
may be
infirmity,
whatever may be the caption. My lord, kindly see the court had to recall the order. Court to recall the, it may be 150.
Tell me under what provision?
151.
For that miscellaneous case is not maintainable. Miscellaneous, Mr. Chakraborty, for 151 is a miscellaneous case is to be registered.
No, my lord.
You apply under the, that is why I give you liberty to apply under the correct provision.
My lord, there is no suit, my lord. If there is no suit pending, whether any application may be made, my lord, kindly consider this aspect.
Mr. Chakraborty, show me the infirmity in this order. Please show me.
Then, my lord, give me liberty to file my lord application, my lord, on 151. 151, I shall apply.
This, I'm not mentioning any
This revision application with liberty to file afresh, my lord.
Why? What's the mistake?
My lord, the mistake is that my lord, no relevant document has been annexed with
What is the relevant document you need?
nothing else. And my lord, there are
Let
several.
me see. Yes, please
then-
come after 5 minutes.
Yes.
Yes, what is the impugned order?
Matlab, the impugned order, by the impugned order, matlab, 3 months after the alleged date of Muller's dispossession, an application for restoration of possession has been filed, and Muller's the court allowed the restoration of possession with police help. And the only ground is that the court on intuition feels that Muller's the plaintiff has been dispossessed in violation of the order of injunction.
Yes. What is the relation between you and the plaintiff?
Matlab, I am the landlord, he was the tenant. There was a tenancy agreement that has been ended in July 2023.
July 2023.
Ended. And Muller's thereafter, Muller's they have vacated the position in Muller's 2023, December 2023.
They vacated when? 20th of
December 2023.
Vacated.
Yes, my lord.
And tenancy expired on?
July 2023.
July 2023. Tenancy expired.
Yes, my lord. And
yes,
they, my lord, filed a suit.
Yes.
19th of January 2024, alleging, my lords, that we are going to dispossess them.
Yes.
My lords, they obtain an ad interim order of injunction.
When?
On 19th of January 2024. Thereafter, my lords, we appeared, and my lords, we filed written objection. My lords, the order 13 rule 1 and 2 has not been heard finally. In the meantime, on my lords, on July.
The ad interim order of injunction?
Yes, my lord. 20.
Page 20.
20. Plus, no document of possession has been filed.
Document of?
Possession. That they are in possession. No document of possession has been filed.
What document can be filed by a tenant to show that they are in possession?
They can file electricity bill. They can file any other gas. This type of thing. This type of papers they can file.
Show me the document that possession was handed over to you.
Malas, I have said that verbally it has been handed over. And Malas,
there is no document.
And Malas, another thing is that
there was a document.
Malas, there is a police case which Malas admits the possession. There was a charge sheet filed and the police investigated and Malas said that I am in possession and Malas, they are disturbing my possession.
Show me the complaint before the police.
Yes.
When did you lodge a complaint before the police?
This is on Malas 20th of March 2024.
Where is that?
Page 2022.
Page 2020, page 22.
Sorry, Malas. 22. 22.
Yes. This was dated?
Malas 20th of March 2024.
20th of March 2024. Yes.
In this matter, FIR has been lodged and charge sheet have been submitted. That is page 24 if your lordship comes. This is the charge sheet and page 25 is the brief facts of the case at the bottom.
What is page 19? 19?
19.
Yes.
This is the previous and complaint filed before the police.
Yes. What is the complaint? Please place that.
Yes, my lord. In that complaint, my lord, it has been said that my lord, there was a dispute between us for my lord's rent, realization of rent, and that is why a altercation took place.
When that altercation took place?
My lord, in this complaint, it has been alleged on 6th of January 2024.
So 6th of January. Yes.
And page 25, if your lordship comes, this is the
altercation took place. Yes.
And page 25.
Page 25, yes.
Page 24 is the charge sheet started. Charge sheet started on my written complaint on 20th of March 2024.
Yes.
And 25 is the brief facts of the case. That is the facts the court, the investigating officer finds after investigation.
What investigation? What was found?
The instant case was started on the basis of written complaint of Maskuda Begum, that is the wife of the defendant and landlord, against the accused person, namely Sariful Islam. This is the tenant and
This
tenant.
was with regard to assault and other things.
Yes, and kindly
This is
see.
nothing to do with the tenancy.
Yes, kindly see, at about 1:30 hours, above noted accused person coming at the complainant husband shop Orchid Varieties.
When? At about
19/3/2024. Yes, page 25.
Yes.
The facts of the case.
Yes.
Fourth line from the top.
Yes.
Fifth line from the top. To the effect that on 19th of March 2024, at about 1:30 hours, above noted accused person coming at the complainant husband shop Orchid Varieties situated at Mamangachi Chomatha and destroy the shop banner and other articles.
Where is their application for restoration of position 151?
Yes, that has not been entered.
Please give me the copy. You have filed any objection to that application? Please give me those.
I have folded the their application and
Yes,
my
sir.
objection as well. They allege that on 15/4/2024, they have been dispossessed.
15/4.
2024.
No. 15/4. No. 5th of February, you have broken open
They have
the padlock.
Yes, thereafter, if your lordship see, on the subsequent paragraphs, they have saved ultimately on 15/4/2024, they have been dispossessed. In the subsequent
On
paragraphs,
7th
they
of
have saved.
April, along with their trying to make pakka construction, pakka wall by breaking the padlock. Which paragraph you said?
Paragraph, I have not noted.
Oh. You said 15th of April?
Yes, Manoj.
1st of April also you have broken open. Can become furious along with their entered into the shop room and taken away. Shop room more than 90 and destroyed. And where is your written objection? Is this?
Yes, ma'am.
This page which you have folded?
Yes.
So which paragraph you have stated in the written objection that you have taken possession when? Please
Yes,
mark me, please show me that. Which page?
As paragraph 8, my lords, if your lordship kindly finds. As paragraph 8, starting from the bottom of the page. Starting from the bottom of the page, my lords, paragraph 8. And thereafter continuation of the paragraph.
Yes, next page, 20th of December 2023. Yes.
Yes, my lord. And also,
Any decision you want to rely upon?
Malas, this is entirely based on facts. Malas. And Malas 151, Malas, they have preferred 151. Malas, they have not preferred many Malas contempt.
Order that and rule 12 they have not
Then,
filed.
yes, Malas. And Malas, restoration of position with Procedural, Malas. If you lost, Malas. Malas, kind. Reasoning has been assigned, Malas. Malas, the court specifically said there was the electricity bill of November 2023.
Yes.
Nothing after that.
And you have taken possession in September.
On Malas, December 2023.
Or December 2023.
And November 2023, the electricity bill has been paid.
Yes. This application under Article 227 of the Constitution
20 on behalf of the petitioner, Mr. Rai is there, Your Lordship. Please do the, sorry for the indulgence, Your Lordship. Item number 20 on behalf of the petitioner, Mr. Rai is there in this matter, Your Lordship.
Sir,
Mr. Rai, Parthopratim Rai is there, Your Lordship.
Mr. Parthopratim Rai is a busy advocate. He cannot be found now. Yes, call the next matter.
29, my lord.
Yes, yes.
Appeared on behalf of the petitioner. 21.
Yes. Yes, yes, 29. Why are you moving back? Yes, yes.
I think when Parthopratim is there, my lord.
Mr. Parthopratim Rai is leading you.
No, no, no.
So,
My lord, defendant number 8 before your lordship, my lord.
yes.
My lord, plaintiff filed a suit
Yes, yes.
for my
Yes.
lord, employment of my deceased father. Employment of my deceased father. He was
Compensate appointment.
no, no. He was died in harness during
Yes, appointment.
while in service. Yes, my lord. Thing is that my lord, he is not. She is not dependent. Plaintiff, she is married, daughter of the deceased. I am, my lord, unmarried daughter of the deceased. My lord, the rule says that only dependent definition.
What is the impute order?
A granted injunction, my lord, restraining from giving employment to me.
Where is that order?
That is that impugn order, your lordship will find.
Yes. But this is an injunction order.
The injunction are restraining.
Civil division application is not maintainable.
I mean, thereafter, my lord, I preferred, my lord, miscellaneous appeal.
Yes, what has been done?
The appellate court, my lord, refused to grant any stay of this.
Cannot be done, sir.
I am coming. Both the court below, my lord, only consider, my lord. Both the court below has not considered, my lord, this.
The stay application cannot be
NCWA agreement.
stay cannot be allowed. I can only direct the miscellaneous appeal to be heard out expeditious.
Considering my relevant provisions of law.
Has to be.
Yes.
How
Because
does
the-
Ashun, this application under Article 227 of the Constitution of yes.
Plaintiff is the petitioner before your lordship.
Din. Filed the
Repairing
bill.
application allowed, repairing application allowed on the basis of the commission report, which has been done in violation of the order passed by the coordinate bench of this honorable court. Only one thing I am drawing.
What is the violation, Mr. Rai? Violation of the order of the coordinate bench. Coordinate bench said no commission to be.
It was directed that the
it
should contain the minimum repair that would be necessary for the
Item, Mr. Rai.
20.
20. Dismiss for default.
Oh.
You are saying pass over.
Malad, I mentioned the matter, Malad, regarding this matter.
Any other side is there? All right. কোথা চলে গেছে ফাইল তাহলে আনিয়ে নিন আনিয়ে নিন
Item number 30.
Yes.
And for the petitioner, my lord, this is an application for an expeditious disposal, lordship.
Of what?
Of an application under Order 7, Rule 11 to the counterclaim file, lordship. I am the plaintiff in the matter. There was a leave and license agreement.
Order 7.
Order 7, Rule 11, lordship. That application is pending since
This is item number 30.
30,
30 Dublin na 31 Dublin.
30, lordship. 30.
You are in 30.
30, lordship.
3522.
This is 3522, lordship.
কি ফাইল দিলেন 29 টা দিয়েছেন
Lordship, I am the plaintiff in the original suit, lordship. There was an agreement with the defendant, a leave and license agreement.
So you want the order 7 rule 11 to be disposed of. What is the next date fixed?
Lordship, the next date fixed. Just a minute, lordship. It is in the month of
January 6th of January 2026.
Lordship.
It's otherwise ready for hearing. Written
Yes.
objection filed.
No, lordship, they did not. There was only taking adjournments only on
This
their part.
application under Article 227 of the Constitution.
The plaintiff petitioners. I am for the plaintiff petitioner. But,
yes.
Lordship was kind enough to grant me leave to file this because they were not inclined to take this after even affirmation. There was a small mistake in the impugned order. It was written as title suit. It should have been ejectment suit. Everywhere else it is ejectment suit. I have filed the collective information copy.
All right.
Information copy. Slip. Information.
It is the
it has been rectified by the court below.
Now it has been rectified.
It has been rectified by the court below. But the certified copy we haven't yet obtained. That will take some time.
All right.
Lordship.
Yes.
Lordship. It's a rejected suit. This was filed in 2004, subsequently transferred to the present court below in 2014. Now, with the passage of time, my husband and my mother-in-law, who were owners of the property, they had died, substituted by the present plaintiff. I am representing the present plaintiff, and the original defendant had also died. That was on original defendant had also died on 21/6/2006. Now the origin on
6/2006,
the original defendant.
Yes.
Original defendant was substituted by his wife and the 4 children, 3 sons and 1 daughter.
Yes.
Okay. And thereafter, till the impugned order, none had come to contest the suit. The suit is running ex parte after having the service effected on them in the course of time, excepting one, defendant number 3. Now, defendant number 3
was contesting.
Defendant number 3 is only contesting.
All right. Yes. Others were contesting.
Others were not contesting.
They were ex parte.
The suit is running ex parte against them.
Yes.
Now, after that, the defendant number 3 died on 28/2/2021. 28/2/2021, the defendant number 3 died.
Yes.
Now, Lordship, the defendant number 3 had taken out 3 applications. The deceased, the heirs of the deceased had taken out 3 applications in a row. And first was under Order 1, Rule 10 for adding them as parties. This was dismissed for default as they did not turn up before the learned court. In due course, they were show caused also prior to that. And thereafter, again, on the same cause, another application under Order 1, Rule 10(2) was filed, and this was disallowed on the ground stated therein.
This was allowed.
This was disallowed. This was
Rule 10 was disallowed.
Yes, it was rejected.
Yes.
Then again, on the third application, they had filed a third application, and Order 1, Rule 10(2) was allowed by the learned judge.
Show me
And
the earlier
applications
rejection.
are there.
Show me the earlier rejection of Order 1, Rule 10.
Yes, the earlier order of rejection is on, where is that?
Page 27.
Page 27, my lord.
Dismiss for default.
This is dismissed for default. And then the second one
Page 30.
is on page 31. 27. Nah?
That was dismissed for default.
Yes.
And then page 30.
And then page 31.
Yes. So now that has been allowed.
On the same call. Now this is,
sir, you are the beneficiary of this order.
Yes.
Otherwise, the suit has abated. It's your responsibility to substitute. If you have not substituted, the suit will abate.
Yes.
So you cannot evict them, sir.
Yes.
Why are you challenging this order?
Lordship.
Why are you challenging this order? Suit has abated.
Yes.
So it's your responsibility to substitute.
Yes.
So if you have not substituted, your suit abates. You cannot get a decree. You cannot evict them. Why are you challenging this order?
Yes, my lord.
So,
yes, my lord.
Now what do you want to do?
The order,
If it is allowed, sir, you will be in difficulty.
Even then, they cannot be substituted. The linear descendants of the deceased defendant, they do not come under the joint tenancy. The joint tenancy survives. Suit is running ex parte against them. One of the defendants who was.
They are not joint tenants. They are tenants in common.
Tenants in common.
Yes. So if one of the tenants in common dies,
yes,
they are heirs unless you implead.
Yes.
Gone. Jawaharlal Shah.
Yes.
Yes. So you will be in difficulty, sir. Why are you challenging this? Because you have not substituted.
Yes, my lord.
Suit has abated.
Yes.
So you do not have now to pay for setting aside even. Why are you challenging this?
I'll take the instructions of my clients in that.
What
event.
Instructions? Sir?
Then I'll withdraw this application, my lord.
Yes. After some argument. Acha. Call the next matter.
Your Lordship,
Yes. Yes, yes.
Your Lordship, extremely apology. Your Lordship, the facts is in a nutshell is I have been implicated as a defendant in a suit in 2014. Now, be that as it may, Your Lordship, the suit is proceeding, nothing is happening. Now, the plaintiff has gone into liquidation sometime in December 2017. Kindly comes to para 9 of my application.
What do you want, sir?
Yes, now in February, I have filed an application under Order 7, Rule 10. Because, Your Lordship, the suit emanates from a development agreement, so it has to be a commercial suit.
Sir, what do you want?
Your Lordship, expeditious disposal of the application filed in February 2025, along with a direction that the suit.
Application for what?
Your Lordship, application for the transfer of the Order 7, Rule 10, Your Lordship. This is a
Where?
commercial suit.
It is it is fixed for hearing when?
Your Lordship, kindly comes to the order dated. Your Lordship, the others, the plaintiff who is the respondent in that application.
Sir, which order records that?
Your Lordship, it starts from 27th March. Kindly comes to 27th March 2025 order.
What is the next date fixed for hearing of that application?
The next date fixed is, Your Lordship, the next date is fixed for 28th December.
28th or 20th?
28th October, 28.
You said December. That is why.
No. I'm sorry.
The application under Article 227 of the Constitution of India is at the instance of the defendants praying for a direction upon the learned civil judge senior division Baripur to dispose of title suit number 323 of 2014 expeditiously. So the learned advocate appearing for the petitioner submits that the petitioner filed an application under Order 7 Rule 10 of the Code of Civil Procedure, which is still pending, and prays for a direction to dispose of the same expeditiously. He further submits that 28th of October 2025 is the date fixed for hearing of such application. So, in view of the order sought and proposed. Next, in the light of the submissions made by the learned advocate for the petition, CO number such and disposed of by requesting the learned civil judge senior division at Baripur to take up the hearing of the application under Order 7 Rule 10 of the Code of Civil Procedure on the next date fixed, that is on October 28, 2025, if the same is otherwise ready for hearing, and to make an endeavor to dispose of the same as expeditiously as possible without granting any unnecessary adjournments to either of the parties.
Your Lordship, one indulgence. Your Lordship, one indulgence. Your
Yes.
Lordship, the plaintiff in the suit has been gone into liquidation, Your Lordship. They are not
Yes.
filing any objection to it, Your Lordship. Kindly record that if the objection is not filed, let the hearing proceed. Your Lordship, they are not.
Yes. Call the next matter.
Lord, 30, I am for the petitioner, my lord. I am the defendant 2, 3, and 4 in the my lord money suit. My lord, there is some delay in filing the written statement, my lord.
There is
some delay in filing written statement.
Commercial suit.
Commercial suit.
What is the period of delay?
My lord, delay, my lord, 160 days has been caused.
Cannot be done. After 120 days, sir, cannot be done. I'm helpless.
Yeah,
that has been rejected. Rightly rejected.
151, Lord, your lordship.
No, 151, sir. Supreme Court says no. This application under Article 227 of the Constitution of India is an You have
My lord,
been
please-
briefed in this
No,
matter.
I have not been briefed, my lord. I am seeking time and the instruction is to seek. Thirty-four and 35.
What is the order impugned?
I do not know anything, my lord. I don't even have the brief. I'm sorry, my lord, but I don't have the papers.
You have
with
not
me.
yet been briefed.
No, my lord. In this,
Yes, want it after the vacation or tomorrow?
after the vacation. That is my instruction, my lord.
Mr. Chakraborty. Call the next matter.
But I am the petitioner. But in this matter, what happened? Application under 13B of Hindu Marriage Act was filed by both the parties. As your lordship knows, but as we every day do, but in the compromise petition, the parties agreed to certain terms and conditions. One of the terms was that the female child of 5 years of age will be in the custody of the mother. Now, my lord, it was joint petition. Now, my lord, the husband filed the affidavit of evidence under order in Rule 4. He has categorically stated that it has been agreed between the parties that the girl child will remain with the custody of the mother, but subject to my visitation as and when I desire. So the parties agreed. Learned judge passed the decree. As you know, my lord, normally this compromise petition itself forms the terms of compromise. Now the husband thereafter filed an application of suit under section 25 of the Guardianship and Act. And he asked for interim custody of the rather permanent custody in the section 25 application. Now the question comes whether my junior filed an application under Order 7 Rule 11.
This Order 7 Rule 11?
Yes, my lord. That is the only point to be decided by your lordship, whether Order 7 Rule 11 applies or not. My lord, whether it is a suit or a proceeding.
No, even assuming that it applies to that.
But there are a number of judgments of division bench and the Honorable Supreme Court of India that whether irrespective of whether it is a suit or proceeding, Order 7 Rule 11 will apply.
No, maybe
because it is otherwise barred under Order 23 Rule 3A. It is otherwise barred. That has been held by the Honorable Supreme.
Show me the compromise terms of compromise.
Kindly look at the affidavit of evidence. I've found
Show me the compromise decree.
Yes, compromise petition.
Or that terms.
Yes,
only.
yes.
Only that term with regard to the child.
Page 21. Kindly come to page 21. This is not by brief. Page 21, Milord, para 10 at the top. Both parties, after effective discussion with each other, the parties to the suit have decided amicably that the minor daughter will be in custody of the prisoner. The prisoner shall have the liberty to visit the child according to his convenience. And the affidavit of evidence. Kindly take up page 25. The affidavit of that 25 is the order.
Show me the guardianship application. Where is that?
By inadvertence, sorry. Section 25 application, I'm sorry, inadvertently it has not been.
Please give me a copy of that.
Yes, the certificate copy I have with me. Certificate copy, the prayer is at. Yes.
Show me that.
May I mark? This is entire certificate copy. Appointment of guardianship. Seat of Kotu. Yes. Appointment of guardianship and appropriate custody.
But can these proceedings be rejected? Because there are several prayers in that. One of the prayers may be barred, not the others.
To that effect, my lord, time to time put up application has been given and my instruction is right today put up application has been filed for hearing of this ad interim custody. And my lord,
But I'm saying Order 7, Rule 11, Act 8 case cannot be dismissed.
yes, my lord, I shall show you, your lord.
For what?
Subject to correction, my lord, one judgment is there.
No.
My lord,
Please allow me to make my
Sorry,
observations. If in a suit or a proceeding,
Yes.
there are several prayers.
Yes.
One of the prayers is barred by law,
Yes.
not the others.
My lord, if
So
that
can it be rejected as a whole? Because plaint cannot be rejected partially.
yes,
in part.
yes.
So if that is so, cannot be this Act 8 case, plaint cannot be rejected under Order 7, Rule 11 as in totality. And also it cannot be rejected in
Well,
part.
as far as prayer A is concerned, prayer A and B is concerned, but that should be rejected.
So no, cannot be done. That is why I'm asking you.
But-
Can that be that can be dismissed at the final hearing?
Yes.
Not rejection of plaint.
But your lordship will kindly look at the impugned order. Kindly have a look at the impugned order.
Yes.
The view of the learned trial judge.
Yes. Yes, but it has been held.
আমার ভিতটাই মার্ক করা internal page 5 of the impugned order.
Yes, internal page 5. Yes.
কোনটা? এই তো পরের page. Yes. The third paragraph. It has
Yes.
been examined by the learned advocate that even if there was any mutual agreement arrived at between the parties, thereby restraining the prisoner husband from his statutory rights, the said agreement was against public policy and unlawful, for which no binding obligation can be imposed upon him.
That is their that is the submission. What is the finding of the court?
Kindly come to page 7. Page
Yes.
7. Since the second paragraph.
Yes.
Since this is an independent proceeding, I have the considered opinion that the aspects of this case should ideally be adjudicated on the basis of adversarial claims and contentions as well as the evidence brought forth by the parties. Moreover, the said decree cannot be modified to curiously incorporate the exhaustive clauses for guardianship, visitation, and custodial arrangements. Those such disputes are required to be reopened for an independent, in-depth evaluation and assessment of the situation vis-a-vis the change in circumstances or subsequent development. Pausing here for a moment, no change of circumstances has been pleaded. If any, the pivotal factor of the
But
welfare
even
and
if I'm not with the learned judge with the observations, but the ultimate conclusion is correct. Plaint cannot be rejected, even assuming that two of the prayers are barred by law, but the third prayer is in tune with that.
My lord, may I now say one thing? My lord, one court having jurisdiction have passed a decree for mutual consent. But if it amounts to a modification of that decree, in my respectful certainty, it could have been done by that court only, which passed the decree.
This is
Not
visitation.
by the substitution under section 25.
So visitation in tune with that.
Visitation I have
Those are not barred by law. So you can make those are disputed questions of fact, can be decided. But even if assuming two of the prayers are barred, this proceeding cannot be rejected.
Kindly look at judgment of division bench judgment of our High Court.
Can be rejected partially?
No, that question didn't arise.
Yes, I'm on that. I'm on that.
The moot question is this, Lord, if it amounts to if it amounts to a modification of a decree or variation of a decree, it could be filed done by that court only.
That you can that
I have pleaded.
No, that you can ask. That cannot be a ground for Order 7, Rule 11. That cannot be.
I have taken points. So one is
Rule 11. That cannot be a ground.
Order 7, Rule 11, because of it is barred by law under Order 23, Rule 3A. This court could not hear out the matter. He could have at best prayed for modification before the decree.
But those two reliefs, not the third one. Visitation, he is not praying for modification.
Kindly clarify that.
What? That will be decided at the time of final hearing.
That is the moot question. Today, suppose that today, my lord, interim custody is granted by the court below. My lord, what will happen? That will amount to variation of the decree. passed jointly. Order 18 rule for.
Take submissions with regard to that.
But submissions have been made. That is no.
Custody has not been decided,
I have
sir.
filed the objection. Submissions made. I personally argued
Show me that the temporary custody has been allowed. Show me.
Yes, my lord.
Where? Where?
এর আগেও তো আছে ইন্টারিম কাস্টডি হয়েছে ভিজিটেশন হয়েছে তো ও আচ্ছা that is pending that is
what I am saying. Your application under order 7 rule 11 rejected. So according to you, two of the prayers,
yes,
or one of the prayer, guardianship prayer is not in that. Practically, custody prayer is in that. One of the prayers is maybe barred according to you. That cannot be a ground for rejection under order 7.
But that your lordship will clarify. Your date is fixed the day after tomorrow. For what? That interim custody, my lord, so that no order for interim custody is granted. I shall serve a copy of this petition to the other side. Lord, your lordship will fix on the reopening day. In the meantime, no interim custody should be granted.
No. For what I shall keep it pending? For what? This is against rejection of plaint.
Yes.
Rejection of plaint, your argument is that the custody matter cannot be decided.
Yes.
So there are other prayers.
Yes.
So if even assuming one of the prayer is barred, other prayers are there. So that cannot be a ground under order 7 rule 11.
But if that is the observation of your lordship, when the matter will be hard day after tomorrow, Lord, today at 2, Lord, if it is hard, Lord, an interim custody is granted.
You can challenge that.
Lord, that will
in anticipation I cannot pass.
Kindly see. Lord, kindly look at these.
In anticipation I cannot.
Only one judgment, kindly.
Yes.
And kindly, it's a division bench judgment of Karnataka High Court.
Yes.
Kindly come to paragraph 8 of this.
Paragraph 8, yes.
Lord, may I read out? In somewhat similar circumstances where there was a decree for divorce granted under the Special Marriage Act, and under that decree, the wife was required to make the child available to the husband every Sunday for 2 hours at the agreed place, and there was non-compliance of that direction. When the husband approached the court under the Guardians and Wards Act, the Calcutta High Court in the decision in Mrs. Shubhani Banerjee and Tapan Kumar Mukherjee pointed out that the remedy for the husband was not under the Guardians and Wards Act, but he had to approach the particular court under the Special Marriage Act for enforcement of the direction given in the decree. Therefore, it appears to us that once the parties have approached the appropriate forum for dissolution of their marriage and has obtained an order regarding custody of minor child warrant from the said court for any remedy pertaining to the custody of the child in alteration or that direction, the parties should approach only the court before whom the proceeding under the said Hindu Marriage Act was initiated for divorce. And then kindly come to paragraph 11.
Yes.
The last part. The third line, starting from the objection. The objection is on account of the fact that there was already an order passed by the learned civil judge Bombay in the proceeding initiated before him under the Hindu Marriage Act by the parents of the minor child, and in that proceeding an order has been passed as provided under section 26 of the Hindu Marriage Act, and therefore for any further alteration in that regard the parties and to approach only the learned civil judge Bombay, and that the remedy under the provisions of the Guardians or Wards Act is unavailable to the parties in such a context. If that be so, the neither section 21 of the Civil Procedure Code nor the decision pressed the service of the learned advocate for the park would have been then 12. Therefore, it is clear that the parties have to approach only the learned civil judge Bombay before whom the proceeding under the Hindu Marriage Act has been initiated and who had passed the orders regarding custody of minor child to get redress in that regard. In that view of the matter, it is to be held that both the petitioner filed in the grandparents and father before the family court invoking the jurisdiction were liable to be dismissed solely on the ground for want of jurisdiction, and if that be so, it is quite unnecessary to embark upon any further decision on the several other points urged on behalf of the grandparents. Therefore, it is clear that so and so, so and so.
So I allow you to urge this point before the learned trial judge.
Yes, I have already urged. I have already urged.
It has not been decided till now. Not on order 7 rule 11. You have said temporary custody is pending there.
Yes.
Temporary custody is pending there. Raise all these points that temporary custody cannot be granted in view of this decision.
Malad,
Today is the date for hearing.
yes, that point has been taken in the Order 7 Rule 11 application itself, and the application as a whole has been dismissed. Kindly appreciate that.
Sir, there is Order 7 Rule 11 has been dismissed.
My
The
lord.
application for temporary custody is fixed.
My lord.
So according to you, that cannot be decided. Here, they have to go before that
court.
That court.
Yes.
Take that point. That hearing
point
is,
I have taken, my lord.
you are saying today is the date fixed for hearing. How can I
No,
take? You have taken that point in Order 7 Rule 11. I have appreciated
Malad,
that.
Order 7 Rule 11 application was heard on 3
Right.
occasions.
Ashwin,
It has
this-
heard and this
Right.
point was taken.
By the order impugned, the application under Order 7 Rule 11 of the Code of Civil Procedure stood rejected.
previously occupied, my lord, that your lordship will kindly, my lord.
How the child is previously occupied, sir, during the puja? For what?
কাগজ আছে? কাগজ আছে?
Take those
তাহলে
points.
ওখানে দেখাতে হবে।
Take those points there.
My lord,
Sir, please don't
kindly
take
grant
Sir,
this leave,
please,
my lord.
you have also a responsibility.
Yes,
So
of course.
he's
of
also
course.
a father.
Yes, yes.
So he also
A biological
has
father,
Yes.
every right.
So legal points are all right.
Yes,
You
yes.
can fight it
Well,
out.
let
in
there
court.
be a fight between the parents, but the child needs
Egos are also right.
Yes,
You
of
can
course.
also have your egos.
Yes.
Nothing will happen if you get the
Child
child
it
for
happens.
2 days.
And
Nothing will happen,
not
sir.
only,
Don't say that the child is preoccupied during the puja.
my lord, only kindly grant me this liberty to my junior to communicate the gist of this.
Yes, yes, that is already there.
Really add this sentence.
The petitioner will be at liberty. The learned advocate on record. Yes,
Lordship. Lordship, I am for
Yes.
the
Didn't have
like,
shoot it for
18 other side.
immediately.
item number 19. Yes.
Sir, it has been dismissed for default. They did not appear. Lord, I
Yes.
tell you, Lordship, Lord, 21, 97, 99 rejected. They have challenged that order. Lord, the decree or judgment data. Already decree is executed. Bailiff report filed. We got
Have recorded, but since they were absent, I've dismissed it of our default. Now I'm saying revision is not maintainable. Ashun, ওই 19 টাতে একটা order record করে দিন।
আবার ওখানে গিয়ে আর্গুমেন্ট করতে হবে তো কি যাবে?
This application under Article 227 of the Constitution. ওই অর্ডারটাকে এটা ইয়েস ফাইলটা ওনাকে দিয়ে দিন
Item 69 for release, my lord. There is some
69?
69. Is some
69 ta din.
The previous order, my lord, your lordship, identical.
Claim case, accident claim case. রেলওয়ে থেকে যাওয়ার সময় পড়ে গেছিল, পড়ে গিয়ে মারা গেছে। আর আমি কিন্তু প্রসিডিংস এ পার্টি নেই, এটা গভর্নমেন্ট নেওয়া আর লিভ নিয়েছি।
Give me the earlier.
Earlier, my lord, same party, my lord, Subhashindu Das, opposite party. No copy to the okay.
Since I'm
Typed copy of the certified copy of the other judgment. Well, the impugned order is
file it before the vacation bench.
well, the impugned order is typed, my lord. The impugned
Vacation bench.
my lord, kindly, my lord, my lord. Otherwise, my lord, difficult to
Call the next matter.
Supplementary list item number 1.
Extremely urgent. That's why, my lord, it's been done. The superintendent police Kharagpur, my lord, has been directed to appear personally to produce a document. There is no criminal case against me, no contempt against me. In a claim proceeding, the tribunal wants the, my lord, the documents. I can send the documents to, my lord, my officers. I don't.
Where is that? Where is that the document?
My lord, kindly seize the first, my lord, because we don't have the copy. Because we are not parties to the proceedings also.
But original records, Mr. Chatterjee.
Sir, we'll produce. The SP needs to go, my lord, with that. Somebody will, a DSP will go. The SP is directed to, my lord, somebody fell off from the train and, my lord, passed away. And he has a claim, my lord, before the tribunal. For that, my lord, the SP doesn't need to go personally with the documents. And I have also said, my lord, that I will appear, my lord, virtually if need be. There is no claim against me as such. And tomorrow is the date, my lord, of the personal appearance.
So deputy superintendent was nominated to appear personally.
Yes. That is also recalled, and then again, my lord, an order is passed on the next day.
So you are the deputy superintendent.
I am the superintendent. Looks to the first page of the order, the summons.
You must have violated that order.
Not violated anything. Because that order has
a summons was issued to the superintendent, but the same was not complied with.
And then she has recalled it. That it has been recalled. That has been recalled. Kindly seize the summons.
Order has been recalled.
The first order, whereas whereas the matter was again reviewed by the honorable bench, but the summons itself. The summons of the first
summons in page 30.
Right at the end, my lord, it has been annexed as an impugned order.
At the end?
Yes, my lord.
No, end is some power of attorney. Or just prior to that?
Yes, my lord.
Yes, summons dated 19th September.
Yes, my lord.
Yes.
Sees, whereas a police case was, second paragraph, I'll read the entire. Whereas the applicant Reena Das filed the above claim application before the tribunal claiming compensation on account of the death of the victim Shamul Das due to an alleged untoward incident of accidental falling from a train between Bishipur and Kulgachia railway stations on 14th of October 23. Whereas a police case was registered under such and such, dated such and such, over the death of the said victim named Shamul Das. Whereas the matter was again reviewed by the Honorable Bench on 18 September, and the Honorable Bench was pleased to pass an order to recall the bailable warrant dated such and such, and thereby the undersigned herein directed a issue of fresh summons upon you for your personal appearance. I am not the person who threw him out. I have the documents with respect to that police case and not even the SP.
Produce the documents.
I will. I'm saying.
Records, through someone, please appear
Yes,
virtually
yes.
because Mr. Chatterjee.
Because that's my prayer. Looks
Where
to,
is that?
kindly looks to what I believe 31. Kindly turns to first 31. This is written below to the assistant registrar. 31.
This is the letter after issue.
And sees the second paragraph.
Yes.
He is the person who is responsible in that case.
No, Arunoda Chakraborty,
Yes, my lord.
IC.
He is the IC, Uluberia. He is the
He
person
nominated.
looking
The
after- yes.
original document has been deposited.
For personal appearance before the learned on behalf of the undersigned. And the case docket deposited before the Honorable Tribunal. Then sees 32.
No, then what will have to produce?
I don't know.
But Mr. Chatterjee was saying that he will produce the original
Lord,
records.
I will. Whatever the learned tribunal wants, I will. I don't have a problem.
What he will produce tomorrow
Then
through
the
someone.
tribunal would say, my lord, what I will have to produce. The tribunal wants the documents.
No, yes. So what documents have you? Please take instructions. What documents you have to produce?
And the
Because it
problem is I
says
don't
the
have
original
time.
document.
I don't have time. Tomorrow is the date.
Can you not take instructions over telephone?
Kindly records whatever documents are required by the tribunal, it will be before the railway tribunal. And I have also paid for virtual appearance. Sees below
That
32.
facility is available.
Yes, it's available. I will get somebody. Yes, my lord. I have paid for. The learned judge.
Maybe Mr. Chatterjee, you have paid for. Is that facility available, functional?
My lord, that is something that I don't know. If available, kindly, my lord, records or somebody deputed through me will appear.
Somebody deputed through you will appear with the original
appear.
records. You appear
Virtually.
through virtual mode.
Very well.
And then what remains in this matter? What will remain in this matter, Mr. Chatterjee?
Nothing will remain. Nothing will remain. And nobody affected, my lord. I do not know why, my lord, he wants the SP to go. There is no reason for the SP to go.
Something you have violated, Mr. Chatterjee.
I have done
Repeated directions were passed. Maybe someone has
Lordship
not.
has seen it's already been deposited before the tribunal. The tribunal will only see, my lord,
Because unnecessarily,
he
Mr.
has died
Chatterjee,
or not.
it is very difficult to believe that the personal appearance of a responsible officer will be
It
directed.
happens at times. For some reason, I don't know, for power.
No. Maybe for some
I
reason
don't want to get into that.
which paragraph, Mr. Chatterjee, you have stated with regard to that tomorrow is the date fixed
Yes,
for
yes.
your.
No, it's there, my lord.
No order was passed.
No, in the
Your junior said that no order was
summons
passed.
itself, it's there that I have to appear on the 25th of September 25.
No, and thereby the undersigned directed a fresh issuance of some
As such, you are directed to ensure your personal appearance along with the original records
this
pertaining to
application
this.
under Article 227 of the Constitution of India. the এটা that will be better because they will miss out some other page.
No, I'm immediately.
ওই কাগজটাই দিয়ে দিন, উল্টো দিকে ওটা লিখে দেবে। Yes, call the next matter.
Serverটা করে দিও। Serverটা করে দিও।
Supplementary list, item number 2.
Your Lordship, I am appearing for the opposite party in this matter. On behalf of Mr. Rahul Kormokar, we received the intimation of this matter at 12:57 today, and Mr. Kormokar regretfully left the court premises
Mr.
before.
Rai, what are you doing? 12:57, you are notifying them.
In the morning, there is no communication to the lodging of caveat. Just after filing, my lord, we received the noting and accordingly we served.
Mr.
So where's the noting of caveat?
Yes, at the time of filing, we gave the notice. It is not that previously we have received any.
You have filed it today.
Today, the order passed on 20th.
Oh, ওটাও কি supplementary list?
Your Lordship, kindly, our humble submission is to kindly fix a date tomorrow at any
Because I
time.
got the impression that
That
sorry.
much.
Yes.
Only one thing, there is a dispute between the. The
What
order.
is the order impute?
Yes, there is a dispute. The wife was
Mr. Kormokar.
Mr. Kormokar is in a different court, Your Honor, and he left the premises before receiving this.
That cannot be a ground. That cannot
Kindly
be a ground.
fix a
Who has
time.
lost the caveat? You have lost the caveat. Where is Mr. Sumitra Das?
We have no instructions, Your Honor, on behalf of him.
Yes,
Kindly,
only
Your
one thing. There is a
Lordship,
dispute between the parties and it was going on since
Yes, what
last
is the
10 years.
impugned order? What is the
Now I can turn to the order impugned once.
yes?
our humble submission is to kindly fix any time tomorrow. Mr. Kormokar will conduct the matter tomorrow at any time, Your Lordship.
What is the you cannot wait till tomorrow, Mr. Rai?
26th, I have to go to Bardhaman along with my
26
child.
is
Day after tomorrow.
day
Right?
after tomorrow.
Anything if it happens, only remains make the matter tomorrow for us. I have no opposition, but I have to satisfy lordship whether there is imminent urgency regarding this or not.
Yes.
Your Lordship,
আমি তো বলতে বলেছিলাম
Please wait, let him submit. Sir, when you have lodged the caveat, you must be ready with the matter.
and this
At any time, it may be taken up. Yes.
এটা কি
Yes, yes.
ইয়েস আর তোরটা কেন ইয়ে করছিস এটা what?
Yes, Mr. Rai, why are you
If
getting
somebody is
agitated?
putting everything
Why are you getting agitated?
if your lordship I can turn to the order impugned. That is
Yes.
20th 9 2025.
Yes. Yes.
Where your lordship, this is a dispute between the husband and the wife, and a custody proceedings has been initiated. 2024, the first order was passed for the purpose of visitation. I am drawing lordship's attention to the said order.
What do you want by this order? What has been done?
Directed to, I have to go with my child at Bardhaman. That the petition filed by the petitioner husband. Right, next page, my lord, the order portion. The petition filed by the petitioner father by petitioner such and such is allowed. The father petitioner have permitted to temporary custody of his minor son in order to ensure the opportunity to experience his own residential family puja in the ensuing festive season commencing on 26th. With the company of the respondent mother, in order to avoid any kind of adverse impact on the tender mental faculty of the said minor son, who is accustomed to have care and love with the mother respondent so far from his boyhood. And respondent mother is hereby strictly directed to comply this order, ensuring the temporary interim custody granted in favor of the father petitioner.
What is the age of your child?
16 years, and not a single day he is staying without me. The father is getting access.
That is why, Mr. Rai. So, what is the problem?
The
Family
father
puja.
has to go. The mother has to stay over there for the night. allowance for 15 days. With whom can he consider?
15 days.
Yes. 26 to 4th. Thereabouts 9 days, not 15 days. Enter Puja vacation.
And from 9th, examination is
The father he got a visitation right for every alternate Saturday for 1 hour. That is before in the court premises. Challenging that before your lordship, that application is still pending. And this order, there is not a single day that he is stay. I could understand, yes, throughout the day he will be stay with his father. That is, I have no objection.
So during the daytime, you do not have any objection.
No.
So if that is so, Mr. Rai, where are you staying?
I am staying at. Yes, I am staying presently as my lord Krishna.
No, but
As Bor-
two things. Where is the husband or the father residing?
Father is.
You have to take.
Barak
You have to take the child to.
Child to Bordhaman.
So Bordhaman, if you are saying that you can allow during the daytime or you can take. So can you return after taking her in the evening and on the next day also? Can you take her?
My lord, I am now staying. কোথায় থাকি আমি এখন? Shodhpur. I am now residing at Shodhpur.
So is it possible for you to
Not
go
me.
every day?
It is not possible for the minor also. I can do everything because the mother I have to do. I am not that.
Alternate day?
Then
Anywhere, Mr. Rai, only one thing. Any accommodation near to that where you can spend the night? All accommodations or all the expenses will have to be borne by the father or your husband.
2 days.
If any arrangement not in the matrimonial
Subject to my lord's approval. Any 4 days.
also
Yes,
traveling.
Yes, that is what.
That is why.
4 days is
Family
there.
puja, Mr. Rai. You
I
also
thought for 7 years there is family puja and the maintenance not paid. The court says payment of maintenance is not a criteria for the I could have
that
is okay.
I will consider. But for this,
Yes, but 4 days.
what
puja,
arrangement can be made?
subject to my lord. 4 days, my lord, the pujas are there. 2 days, if a lordship can accommodate me, I will be there. The son will be taken by the father and return me by the
It
evening.
is a family puja,
What?
Mr. Rai.
A boy.
Soptami, Ostami, and Novami, please.
Consider
Any reasonable accommodation nearby?
I
Do you have
don't
any
know
idea?
that. It can, my learned friend's client can.
Your client will also know she was her matrimonial home was there.
ওইখানে কি থাকার জন্য আপনাদের কোনো জায়গা আছে? 10 years, he has no. I am requesting my learned friend can also apprise your lordship whether there is possibility accommodation or not there. But I don't know if it is in Bordhaman, near to Bordhaman, well, it must be some accommodation.
Is it in the
Puja in Birbhum? Puja is at Birbhum. Subject, sorry, my lord.
Puja is at
Birbhum. Birbhum.
Oh, Birbhum. So you have to go to Birbhum.
I have to go to Birbhum.
So Birbhum, there is, I think.
There must be.
Please take instructions. Also,
Mother
you
only
take instructions during the puja because
I will stay over there.
may not be possible during the night for the for your wife to stay there.
The university is such a position whether the court will take the responsibility of the.
Yes, yes. So it may not be. Hey, live streaming the Yes, that is what matter.
Yes, ma'am. This is an application, my lord, for interim custody, my lord. Now, my lord, I am, my lord, the hearing matter, lordship takes after vacation. I don't have any objection. But during this puja time, my lord, at least 2 days, my lord, my child will, my lord, remain for entire day, my lord. I'll keep it. I'll keep her at 9 a.m. and I'll drop it at 9 p.m. 2 days. No, only I'm seeking, my lord, that I'll pick it up at 9 a.m. and I'll drop it at 9 to
From
9.
where to where?
When she is with my husband now, my lord.
From where to where?
Yes, my lord, in Salt Lake area only, because she is living in Obidipta. Obidipta. So, my lord.
Yes, madam, what do you say?
Your Lordship, two things. I'm being led by Mr. Kaur, my Lord. He had a bereavement in his family, Your Lordship, which is why he had to leave. So the matter, if it could be kept tomorrow, Your Lordship, he could come back and appraise Your Lordship.
Instructions, 2 days.
Only 2
Your
days I'm
Lordship, we
seeking.
have taken instructions, my Lord, and we are not going to be able to accede to that, Your Lordship. We'll explain that we have filed a supplementary affidavit. The child has some serious medical issues.
Yes.
Which is, my lord, has to be taken care of, which is why perhaps we are very apprehensive. And my lord, it is on record tomorrow. If your lordship permits, Mr. Kaur shall come and place it before you.
May I, my lord?
Tomorrow.
May I go before your lordship, my lord? This medical difficulty, my lord, she was having, my lord, already, my lord, as per my instructions are concerned, my lord, now she is all.
Consider tomorrow. Yes, call the list.
At the same time, 2:45, my lordship keeps it.
2:45,
Because at 2 p.m.
3:45, 4:45.
No,
That I
lordship
do
will
not
fix it up, my lord. Our date, my lord, I'll come. That time.
That's only
I know, my lord.
2 days.
I'm not.
This matter was continuing. Special officer appointed.
My lord,
special
serious
officer
problem, my lord, the
changed.
mother is facing.
So only 2 days before the vacation, you have.
No, well, I have already mentioned it prior.
Mr. Chattopadhyay, you have.
Well, only one thing, Mala, may I?
Nothing will happen.
Mala, the mother is really suffering. Mala, the special officers are Mala.
All right, I will consider tomorrow. Yes, call the list.
Let it happen at the same time. Mala. 2 p.m. Mala fixed matter. Mala.
Call the list.
37.
37, yes.
Only.
Since I'm not inclined to take up this matter on personal ground, this matter stands.
Let it happen.
Yes, call the next matter.
Item number 38.
Yes.
Well, this relates to my lord.
Yes, what is the impugned order?
My lord. This relates to, my lord, allowing, my lord, the opposite party in a complaint case, my lord, before the forum, my lord, the commission, to submit the written statement beyond the statutory period, which has been, my lord, a 5-judge bench of the Honorable Apex Court, my lord, has specifically stated that beyond 45 days, under any circumstances, it cannot be. My lord, my lord, take your lordship to the order, and my lord, the fraud, my lord, that they have practiced on the learned court, my lord.
No, this is a revision petition.
Yes, against the revision petition was, my lord, it was allowed. They were allowed to, my lord, file their version, their WV. Against that, my lord, I am before your lordship.
No, the revision petition. In the revision petition, they were allowed.
Yes.
So the original forum, that was rejected.
That was rejected. And against my lordship, my lord,
Where is that order? Where is the order of the 5-judge bench?
Yes, my lord, I'll just another lordship. Lordship kindly takes up paragraph number 52, page 778. Well, from two conflicting decisions, well, this came up.
52. Yes, JJ Merchant.
Yes.
There is by the order impugned, the state
Number 39.
Yes.
Expeditious hearing, my lord. The suit was filed, my lord, in 2000.
Of what?
My lord, of the my lord, injunction application, my lord.
Injunction
was-
application.
Yes, my lord.
You are, who are you?
My lord, I am a defendant number 1, my lord.
This application under Article 227 of the Constitution of India. Who is appearing? None appears for the petitioner at the time of call. No accommodation has been.
My lord, in 41, Mr. Banerjee appears for in this matter, my lord.
Which Mr. Banerjee?
Mr. Owen Banerjee appears. my
Yes,
lord.
yes, you start. Please start. Yes, what is this matter?
My lord, this matter pertains to, my lord.
Don't look at the door. Please look at your brief. Yes, yes. Please start. Please start.
Item number 40, Mr. Suman Chakravarti is appearing on behalf of the petitioner.
Who is appearing?
Mr. Suman Chakravarti. Mr. Suman Chakravarti is appearing on behalf of the petitioner. Is addressing the.
He says Mr. Anand Banerjee is appearing.
My lord, in 41, my lord.
In 40, item number 40.
40.
Kindly make it short, pass over.
Ask him to come. Ask him to come. Yes, yes. Yes, yes. Yes, yes. You start, not Mr. Anand Banerjee. Let him take some rest. He is running here and there. Yes, yes.
My lord, the opposite party is herein. They have instituted a suit for declaration and injunction in the year 2024. My lord, prior to that, the brothers of the opposite parties herein, they have instituted another suit for partition.
Section 10.
Section 10, my lord.
Yes, rejected.
Rejected, my lord.
Yes, Mr. Banerjee. All parties are not the same.
Parties are same, my lord. The second
Court records some are additional parties.
I'll
What are the stages of these two proceedings?
stages, my lord.
Issues framed.
Issues framed. In the first suit, issues framed.
Issues are same.
Issues are not exactly same, but the same subject matter is. I'll just indicate, my lord. The first suit is a large regarding larger property, 38 decimal partition suit. But where the same parties are there.
Banerjee, the basic concept of section 10 is that issues are to be same. If the issues are different, Mr. Banerjee,
one of the
maybe
issues
the
is,
same property. If the issues are same, section 10 is maintainable.
title ownership, because partition upon declaration. First, so my lord, ownership of the property, that is one of the issues.
Partition is the earlier suit.
Earlier suit is partition upon declaration.
Upon declaration of shares.
Of shares.
And what is the subsequent suit?
Subsequent suit is, my lord, amongst the co-defendants. One of the defendant is saying that this
amongst the co-defendants.
Co-defendants. But not in partition suit, not all the not everybody is plaintiff, everybody is defendant. Not second suit, this.
So what is the claim against the co-defendant?
Second suit, no, they say that a transfer which has taken place in favor of the other defendants, that is bad. That is a declaration paid for an injunction regarding that property. So in the first suit, already injunction
Stages of what are the stages of both the
first
suits?
suit issues have been framed. Second suit, we were paying not consolidation, Millard, because in the second suit, all
Because
suits,
Mr. Banerjee, issues are not the same because its plaintiff's share will not be disturbed with regard to the fate or is not dependent on the fate of the other suit because it's a intersect claim between two sets of defendants.
sets of defendants.
So it's the shares of the defendants which may ultimately vary.
All rights are flowing through the same family settlement.
No, Mr. Banerjee,
That
there
is
are two
admitted.
things. The plaintiffs, you are right. Everybody is the plaintiff, everybody is the defendant. But here is the case, plaintiff's share is not dependent on the other suit.
On the second.
It's only shares of those co-defendants which may vary.
Interstate.
So technically, Section 10,
The partition suit, Millard. So, Millard,
maybe partition suit.
interstate amongst all
Mr.
the
Banerjee, partition suit, there are two stages. One is declaration of shares.
My lord.
So far as the plaintiff, there is no dispute.
So far as
So far as the defendants, two defendants, they may have some modification with regard to the shares of these two defendants. If that is so, nothing will happen. Let this suit proceed, Mr. Banerjee. Let this suit proceed till the passing of the preliminary degree. Nothing will happen. If in the meantime this suit proceeds, you can very well take that plea, or Order 20, Rule 18, shares can be modified even at the subsequent stages. You can pray for declaration of your shares, taking help of the decree in the other suit.
Decision of the Millard first suit regarding the ownership is dependent on the same set of evidence. Millard.
Of those two defendants, that will not be.
Only there is a subsequent gift deed which Millard they are challenging.
Yes. So both of them must have a common predecessor or ancestor.
Common
So
family.
one is claiming by virtue of inheritance, other is claiming by virtue of a deed of gift. So only that will be changed. Because the shares of the ancestor, there is no dispute. So your ancestor's shares will be declared. With regard to that, there is no dispute. So Mr. Banerjee, Section 10.
Stage torture for injunction hearing.
Second suit will issue.
Issues are not.
Millard, consolidation can be done, Millard, because
It will delay. It will delay, Mr. Banerjee. Consolidation
first suit issue
will delay both the suits. Consolidation will delay both the suits. It's better. Issues are not the same.
because injunction is subsisting over the entire property. Now in the second suit, they're again asking for injunction over the.
Because that is why the learned trial judge is right. Subject matter is also not the same. It's a part of the partition suit. Subject matter of the same second suit or the declaratory suit is a part of the partition suit, not the entirety. Parties are also different because it's only the co-defendants who are fighting in the second suit. Other plaintiffs are not there. This application under Article 227 of the Constitution of India parties in that suit, Mr. Banerjee.
They have not
You have
been
left
made
out everyone.
No, I have filed the revision in respect to the second suit,
Second suit, you are saying plaintiff pays 65.
my lord.
No.
Plaint is no.
80.
Second suit is my lord 65. So second suit is my lord page 18. I'm sorry, my lord.
80.
18 is the first second suit.
18 is the
Second suit.
There are so many parties.
So they have been made parties.
What have you done?
Party কোথায় করে এসছে?
There are so many parties. Why have you left out them?
It's a glaring mistake, my lord. I don't. Party হয়নি কেন? Not kindly, my lord. We'll have to not kindly allow him not to make the correction. In
On the prayer of the learned advocate, on the prayer of These two not at
3 p.m. to 45 p.m.
2:45. Your matter is at
My lord, I
2:45.
take for unconditional apology, my lord.
100.
No, 40.
Your lordship,
Your lordship, this is for default, the matter, my lord.
on Monday.
46. It can be reached serially, Mr. Chatterjee. I have proceeded up to 41.
No doubt, but if your lordship takes up the fixed matter now, then it will not be reached up to within 4:50, 4:30.
All right, how many quarter fixed matters আছে দেখি বলুন
My lord, item 40, your lordship, please, and this is for default, my lord.
two 45 matter.
My lord, item. Can you the matter? I think code 142, my lord. Kindly, my lord.
That cannot be a ground.
My lord, kindly, my lord.
Page item number
40, my lord.
40. Please wait. I will take it up.
My lord, grateful, lordship. Grateful.
Any caveat is there? Anyone
No,
appeared?
No caveat, my lord.
Yes. 40 ফাইলটা পাঠিয়ে দেবেন না। Yes. 2:45 কত নম্বর আইটেম এটা?
100.
100. You are appearing.
I'm for petitioner.
Yes. Yes. What is this matter?
My lord, the plaintiff is the petitioner herein, my lord. What's this?
My lord, I have instruction to appear, my lord, on behalf of the opposite party.
My lord, I am not
Caveator.
I have not served.
Before the learned court below, they communicated, they are
Yes, ma'am.
challenging that order, they filed a.
Mr. Host, you have not lost the caveat. You do not have a right of audience.
That's true, my lord. Since I have no caveat, but from the learned court below, my lord, I came to know, my lord, and from that, my lord, I got the instruction. My lord.
Give him a copy.
Well-
Give him a copy tomorrow. I will take it up.
Yes, ma'am. I'm giving copy, my lord.
Yes, please give a copy. করার দরকার নেই, রেখে দিন, কালকে দুটো পয়েন্ট ম্যাটার্স 3টের সময় যেগুলো আছে, আর 2:45 আছে, 3টের সময় গুলো সিরিয়ালি রাখুন পরপর। ইয়েস,
Item number 320.
320টা আগে কি
320 with 321.
321, my lord
320.
did not take up. My lord, there are two matters. One is from maintenance, which is 321. My lord, I am not pressing for that. My lord, there is an interim order passed by your lordship. So far as 320 is concerned, my lord, this is a custody matter.
321 you are not, but it is with 320.
Yes. So, my lord, did not take the trouble, my lord, with 321.
320, yes.
320 is a custody matter. My lord, from an order, my lord, providing for, my lord, interim visitation at court premises, we filed, my lord, a revisional application where my lord, modified the order for the time being, asking us, my lord, to take the child, rather to meet the child. The child is with the mother, my lord, at Joy Krishna Library at Uttopara, my lord, every Sunday. My lord, which was happening, but my lord, with some interruptions and all, my lord, we are not, my lord, complaining about that as of now. My lord, Puja is coming. My lord, I just as a father want, my lord, to have my child with me for 2 days. I have a proposal also, my lord, I have.
Well,
My lord,
who are proposing? No one is there to accept
served
your
notice.
proposal.
I've served notice. I've served notice.
Who is appearing, Mr. Banerjee?
My lord, if now, my lord, they avoid, my lord, the honorable court, my lord, I as a father, my lord, can't help myself.
Who is the learned
I
advocate?
tell your lordship, my lord, oh.
Why are you not appearing, madam?
Mr. Anuma Bhattacharya is appearing in this matter, Lordship. They have mailed about the
Both, my lord, mentioning notice and then this also.
already replied. The reply is with me, Lordship, that
True.
he is bedridden in condition.
Bedridden?
Fracture in his leg. It's not coming since 15 days. And Lordship already.
Maybe,
in
but
other
madam,
matters-
only one thing.
Yes, sir.
Can you not consider his prayer? Because after all, he is
May I
the
talk to
he is
her,
the
ma'am?
father.
May I talk to ma'am?
So can the father not take the child during the pujas or keep
And
him
my lord, I have,
for some time during the pujas?
but I have, my
You are
lord, he is
celebrating Durga Puja in your residence, Mr. Banerjee.
no, no. My lord, I have a better suggestion even. My lord, I have a flat at Srirampur, which is under lock and key. My lord, I live with my
Mother
my
stays
lord,
at Srirampur.
no. Mother stays as Uttarpara. I stay at Bhadreshwar, but I have a flat, my lord, independent flat at Srirampur, which is now under lock and key. My lord, if the mother wants, my lord, to be there with the child round the clock, even when the child is with me, my lord, I am amenable to that proposal also. The child may be taken, my lord, to that flat.
Lordship, one day
Very well, we'll come back tomorrow. Very well.
Lordship, tomorrow can Lordship.
Very well.
Please take instructions because his suggestion is that Mr. Banerjee for the entire puja days.
No, for 2 days. Puja, my lord, we celebrate for 4 days. 2 days, my lord, the child may be, my lord, with the mother. My lord, I will not interrupt. 2 days, my lord, the child may be with me along with the mother if the mother wants.
Lordship, it's okay. I will take the instruction, Lordship.
কালকের কালকে রেখে দিন কিছু অর্ডার পাস সেম টাইম কালকে ডেট দিয়ে 3টে
3 p.m.
Yes,
Tomorrow at 3 p.m. Milord will come back. Grateful.
Mr. Banerjee, time may be flexible because
Wait,
I'm not.
Milord. Any time that is convenient
Yes.
to your lordship. Any time. Milord.
Yes. পরটা ডাকুন
Agenda 42.
আর নেই মানে 42 3 p.m. 3 p.m. আর কি ফিক্স আছে বলছেন যে অতগুলো Mr. Chatterjee, you said that your matter is fixed at 3 p.m.
They have informed us that their matter is fixed at 3 p.m. That's why I am fixing.
Who has mentioned? Who has said?
This semi-old man who has, I do not know his name, and Mr. Banerjee.
Those two matters already.
Chief, item number 42, I beg to appear on behalf of the petitioner. I am praying for not to lordship.
Why, sir? Not today. Then it cannot be taken up this side of the vacation.
Well,
Yes.
3 p.m. fixed, Madam Lord. Item number 444.
Yes. Yes, you want?
Not to lordship.
Yes. What is this matter?
I don't know lordship actually. I
don't know.
Not even the
On the
brief.
prayer of the learned advocate for the petition, list this matter after the vacations. Next, call the next matter. 43. 43.
For item number, Lordship's kindly, but item number 444 was fixed at 3 p.m. But the other side is also there, my lord. This matter was not 444. Item number 40 of today's list, my lord, 3 p.m. fixed matter. It is there. Well, this matter was not mentioned, my lord. We were not aware. But well, Mr. Bordhan is appearing, my lord. The other side is also here.
The contested matter.
Contested. No, contested. We want an interim order. My application has been dismissed for default. My restoration application is there. And
Please let me see how far I can proceed with these motions. Please wait. Yes.
Grateful.
None appears for the petition at the time of call. No accommodation has been sought for either. In view thereof, your number such and such stands can be called. Call the next matter.
Number 44. For the petition.
Yes.
Petitioner is the wide, my lord.
Yes.
In the pendency of the divorce proceeding, my lord, section 13 of the Hindu Marriage Act, section 24 of the Hindu Marriage Act and filed, my lord. That was rejected, my lord. Challenging the order dated, my lord.
Section 24 rejected.
My lord. Yes.
You have an independent income.
My lord.
Must be.
My lord, the order dated 7th May, my lord. That is the challenging order, my lord. My lord, that is not the documents. Husband earned 70,000 per month.
Where are you working?
No, the private job. Man, is a private
Maybe
job.
what is your salary?
Salary.
Private job is not a income.
No, my lord, absolutely. My lord.
What is your income from private job?
As per orders, my salary 24,120.
Is presently earning, and the wife has producing documents. So what is your income?
24,120.
120.
120, my lord. But that's why rejected. Kindly stop the copy.
This application under Article 227 of the Constitution of India is at the instance of the wife and is directed against an order being number 47 dated 7th of May 2025 passed by the learned additional district. This application under Article 227 of the Constitution of India is at the instance of the wife and is directed against an order being number 47 dated 7th of May 2025 passed by the learned additional district judge first court Arambagh in this case number 15 of 2023 arising out of matrimonial suit number 46 of 2019. First, by the order impugned the application under section 24 of the Hindu Marriage Act stood rejected. First, the learned advocate appearing for the petitioner submits that the husband opposite party herein is earning a substantial amount of money. Submits that the income of the husband is rupees 70,000 per month. Full stop. He therefore submits that the husband should be directed to pay alimony to the wife. Full stop. husband has gifted a property to you.
That is correct.
That is correct.
My lord.
What more? The husband has given to you. 2013 also, a property was purchased, amount provided by the husband. It appears from the record, no, it is not in dispute that the husband made a registered deed of gift in favor of the wife in respect of 100 square feet godown on May 30, 2017, which is under the possession of the wife petitioner. First up, it is also not in dispute that the husband opposite party provided the purchase money for purchase of a property in the name of the wife on December 13, 2013, when they were living together at that point of time. First up, though the petitioner claimed that the husband is earning a sum of rupees 70,000 per month, but could not substantiate such allegation by producing any materials in support thereof. First up, from record reveals that the learned advocate appearing for the petitioner, however, did not dispute that the wife is a salaried person. First up, from the reply given under the provisions of the Right to Information Act, it is evident that the wife petitioner is getting a salary of rupees 24,120 per month. First up, the learned trial judge assigned cogent since the petitioner has independent income of her own for her sustenance, the court is of the considered view that the learned trial judge was right in rejecting the application under section 24 of the Hindu Marriage Act. First up, for such reason, this court is not inclined to interfere with the order impugned. CO number such and such accordingly stands dismissed. There shall be however no order as to pass. Call the next matter.
Number 45. 45, Lordship. I beg to appear on behalf of the petitioner, Lordship.
Yes.
A judgment, decree holder is the petitioner before your Lordship, praying for expeditious disposal of a miscellaneous case.
Under Order 21 Rule 97?
Yes.
299. How many miscellaneous cases? Only one.
One remains as on date and my execution.
Others disposed of?
Yes. And also, Lordship, if one line can be done with regard to the execution case, it is pending since
By the
2021.
time miscellaneous case will be disposed of, some other miscellaneous case will come. This application under Article 227 of the Constitution of India is at the instance of the decree holder praying for a direction upon the learned civil judge junior division Vidhannagar to dispose of the title execution case number 4 of 2021 expeditiously. First up, to dispose of the miscellaneous case number 34 of 2023 arising out of title execution case number 4 of 2021 expeditiously. First up, the learned advocate appearing for the petitioner submits that who filed that miscellaneous case?
My lord, the judgment debtors.
Judgment debtors, not third parties.
Judgment.
Submits that the judgment debtors / opposite parties herein filed an miscellaneous case under Order 21 Rule 99 or 97? 97 of the Code of Civil Procedure, being this case number
34 of
2023. What is the stage of that miscellaneous case?
Objections are awaited.
So it's also not ready for hearing. He submits that the what is the recalling application 1st of November? He submits that the written objection in the miscellaneous case has not yet been filed. First up, in view of the order sought and proposed recorded from the order sheets appended to this application, this court finds that 1st of November 2025 is fixed for hearing of the recall petition dated March 29, 2025, and for filing written objection in the if any in the meantime. First up, in the light of the submissions made by the learned advocate for the petitioner, CO number such and such stands disposed of by requesting the learned civil judge junior division Vidhannagar to take up the hearing of the recall application dated
Recalling has been disposed of because
when first of
that,
November
that order
2025.
has not been recorded, Lordship. That is the difficulty. Recalling was with respect to a cost which was to be paid by us, paid to us.
আচ্ছা তাহলে করুন।
We have received
From
the
the order
cost.
sheets appended to this application, this court finds that 1st of November 2025 is fixed for hearing of the recall application. তারপরে কেটে দিয়ে লিখুন, the learned advocate appearing for the petition submits that the recalling application has been disposed of and the miscellaneous case is only pending. In the light of the submissions made by the learned advocate for the petition, CO number such and such and disposed of by requesting the learned Civil Judge Junior Division Bidhannagar to take up the hearing of the miscellaneous case number 34 of 2023, if the same is otherwise ready for hearing, and to make an endeavor to dispose of the same as expeditiously as possible without granting any unnecessary adjournments to either of the parties. After disposal of the miscellaneous case and any other miscellaneous cases that may be pending, the learned judge of the executing court is requested to dispose of the execution case expeditiously. Yes, next.
One time frame, Lordship. One time frame, Lordship.
Time frame.
Because this is the execution is of a decree of 1989.
As expeditiously as possible, but preferably within a period of 4 months from the next date fixed, without granting any. প্রথমটাতে দিয়ে দেবেন, পরেরটাতে execution টা।
I'm very good.
46, yes.
This is my application.
There was a fixed matter, it was urgent matter. I can wait.
Please wait, yes.
Someone here, I have moved before one application before DRT, challenging the order of the learned district magistrate.
Section 14.
Section 14, challenging the order of the district magistrate for granting police help. Number the application which has been filed before the learned district magistrate and the order he has been filed, everywhere this is in violation of the statute. That was pointed out before the DRT.
DRT is there, Mr. Chatterjee.
No, DRT. My client has not gone to DRT.
Why are you not going to DRT? Appeal provision, Mr. Chatterjee.
I know. But that is not mandatory provision. I have such. Your Lordship can see May. Your Lordship can see.
What May?
Section 18.
No.
Yes.
Not May, Mr. Chatterjee. The above Supreme Court decisions.
Your Lordship can see any person agreed by any order by the Date Recovery Tribunal under Section 17 may prefer an appeal. May. It's not straight jacket.
Mr. Chatterjee, this provision.
This is my. I know. Only one.
And bound by my own decision, sitting in division bench also, I have delivered. Not because Mr. Chatterjee.
Now the only problem is
decisions you will be finding. Just said in these fiscal matters, other matters. If you have to exhaust the alternative remedy, should not be bypassed.
Your Lordship kindly.
Even taking note of the decision of the Honorable Supreme Court that there are certain exceptions where you can approach under 226, 227, bypassing the statutory remedy after quoting that paragraph, next paragraph, PHR invent. That's the recent decision.
Very well. I'm not on that. I say that during the pendency of the matter, the property has been sold. Sold. Now, only one thing, the amount they are showing this due, payable, 2 crore 71 lakhs. After thereafter, it has come to 2 lakhs, 2 crore 63 lakhs. They have earned 3 crores 30 lakhs by disposing of the property. Over and above, I have paid 45 lakhs. So, there is no due and payable to me. In spite of that, if I want to prefer the appeal, I have to follow this rigorous. Your Lordship, can you see that I have to deposit?
Yes. If there is no date due, you are not required to pay.
That's not there.
Mr. Chatterjee, there is a reference before the Honorable Supreme Court on the Honorable Supreme Court, not a reference before the Honorable Supreme Court. The Honorable Supreme Court has kept that point open and has directed that to be decided. I think
Your Lordship,
you can raise that point.
No.
Help of
Referring that Supreme Court judgment, Your Lordship kindly indicate, Lordship, Your Lordship kindly indicate.
I have a very short memory, Mr. Chatterjee. I have forgotten. Yes. Please, can you give me the citation? Oh, yes, you referred to that decision.
So, Your Lordship, kindly refer that and kindly give me leave to, I shall go to the appeal court. But this is the rigorous. I have to deposit 50%. I have no dues at all. I am challenging the order.
You are the borrower.
I am the borrower.
That is the difficult thing.
No.
Borrower, yes, but if there is no date due.
There is no date due. Admitted, this is admitted fact.
But this decision is on, if it is not the borrower.
Maybe, but the factor the same.
Which paragraph, Mr. Bordon?
ওখানে ওখানে যাই না ওটা ওটা তো অ্যাপ্রোপ্রিয়েট নোটিশ
No,
এটা আমরা ট্রাইব্যুনালে ঢুকে বুঝিয়ে তো হ্যাঁ আমার ডেট ডিউ কি করে হলো ওর তিন লক্ষ
yes, yes, I've seen that. Mr. Chatterjee, have you seen this decision?
No.
এটা দিন তো। Mr. Chatterjee কে দিন। Some relief somewhere, but may not be. But may not be.
My learned junior will say something.
If I can assist this cause, my lord. One of the cause, my lord has very rightly indicated at the outset. Three exceptions: jurisdictional error, denial of natural justice, and my lord, palpable injustice on the cause. Well, this judgment which has been cited, one prefers an appeal and the waiver will apply. One doesn't have to deposit. Only when there are technical issues. Say, for instance, my lord, that an amendment is required to be done and that the learned tribunal has rejected and an appeal is preferred, there the deposit question will not arise. But however, my lord, if the order per se is perverse.
No, he says that there is no date due. Because the amount
possibly, my lord, there is no debt due is absolutely correct. My lord, if I can give an analogy, 100 rupees is the demand. They have sold the property and has recovered 120 rupees. Essentially, there is no debt. My lord, this has to be mentioned before the authority under section 14. They did not do so. My lord, the action is
for the other side.
My lord, I am assisting my learned senior friend. My lord. If
Yes.
my lord permits me, my lord, if I
Yes.
So, my lord, that is section 14, subsection 1, proviso Roman 1. This has to be mentioned in the application, a fact which was submitted before the learned tribunal. Learned tribunal.
Yes, you are right. But those three exceptions in PHR invent, as you are aware,
there are two.
Have taken note of those exceptions. Even then, says no, you have to go there.
The Phoenix
and if there is
judgment
no
PHR
date due, so if there is no date due, you can take that point that you are not required.
My lord, for the purpose of deposit, though there is no debt, though there is no debt due,
yes.
But insofar as the deposit that is required to be made before the DRAT, I cannot take advantage of this money which is been recovered by the bank by selling my asset. My lord, that is Siddha Neelkant's judgment. The Honorable Apex Court has clearly said.
Surface actor.
My lord, I am on a point of jurisdiction. If my lord permits me, I fall within the three exceptions laid down by the Supreme Court in Godrej Sarali judgment. If my lord permits
three exceptions, considering that, I think in paragraph 34 or something, paragraph 35 says no. In the fiscal matters, no. PHR invents.
My lord,
you are aware of those judgments.
My lord, I am aware of it.
Yes.
I am aware of that.
Considering those three exceptions, next paragraph says, so if you cannot say that the Supreme Court was not conscious of those three exceptions. Considering that, next paragraph.
May I come tomorrow, my lord?
Very next
May I come tomorrow? Only on this point, a point of law, my lord.
What
this
point
will...
of law? Prepare an appeal there, so I can give you leave. If you can pray for waiver, you are at liberty to do so. Because
that
section
money
18,
which the bank has recovered, I will not get the benefit of waiver there. Though
50% of the amount of
yes,
is due.
Yes.
There is no due.
My lord, bank commits a mistake and I give the deposit.
No, if there is no date due.
There is no date due. And that has been
That is Mr. Chatterjee's submission. There is no date due.
That has been indicated in the order itself. Order of the
Show me that.
Order of the DRT.
Show me. Page.
The order starts from order sheet in internal page.
No, show me that portion that there is no date due.
That portion
that you have raised that point that there is no date due. Where is that?
Yes. Yes. Your lordship, kindly come to page 4, internal page 4. I have mentioned last time.
Internal page 4, yes.
Of the respondent is that the asset was
Last
sold-
line. Which paragraph?
Last line, Lords.
Paragraph 3.
The contention of the respondent is that, yes,
Assets were sold on 12/7/2024 to a company, namely this, and therefore for a sum of rupees 2,05,000 and 1 crore 25, 2 crore 5,000 and 1 crore 25,000. And thereafter, we have also paid 45 lakhs. Prior to that, we have paid 45 lakhs. That is also recorded. Yes, your Lordship, kindly see page 2. Page 2.
page 2.
Page 2. Page 2, I have paid this thing also. Page 2.
No, how this has been dealt with?
Nothing. Nothing. That's why I am pointing out that there is no debt due. And all these things has to be adjudicated in 227. Otherwise,
So I clarify that if there is no date due, you did not make that deposit.
What I'm saying, heaven will not fall. Not yet the police has taken the.
You have said it has been sold.
It has been sold, but police has not taken any step for recovery of the possession. Possession is with me till date. But only one thing I am praying subject to, because there are certain things to be indicated to your Lordship. Before this side of the vacation, I don't want to trouble your Lordship by indicating all these things.
Mr. Chatterjee, there is a statutory remedy.
I know this is the hurdle, but there is a judgment of Honorable Justice Dipankar Datta in the Supreme Court.
Considering that, Mr. Chatterjee, considering that PHR invent has been
No,
passed.
not PH.
Yes,
It is.
Mr. Chatterjee, we have delivered a judgment sitting with the Chief Justice. I was the author of that judgment. We had considered the judgment of Justice Dottu was also placed before us. We have considered that. Ashun, the file.
Absolutely.
Without the bank, Mr. Chatterjee, it might be
Absolutely.
difficult.
No, no,
Who is
no.
appearing for the bank? Which bank? There is some issue knows who is appearing for the bank in the tribunal. But there, now it's here.
Here, my lord, we are not aware. And
Who appears? Which bank?
my lord, State Bank of India. State Bank of
You know who appears for State Bank of India here.
But my lord, there are many in panel. There are many in panel. We really don't know. And the appellate tribunal will go for a recess from Friday onwards, my lord. And then there is one complete 1 month in between we'll be physically dispossessed. Even the appeal which is available in statute, before we could venture that, will be out of the property.
Considering the fact that the 17th. ये 17th एकदम एक दिन आगे ना. Lucky 13th. It's not a Friday.
This is Thursday.
It's a Thursday.
Thursday.
It's a lucky day for you, Mr. Chatterjee. 13th.
Thursday. Lucky day.
13th.
For what? No?
Yes, yes. Call the next matter.
47.
Yes. Yes. Who is appearing? None appears for the petition at the time of call.
Number 48.
Number 48, I appear on behalf of the petitioner plaintiff suit for declaration, partition and injunction, my lord. Lord, the application for injunction has been filed in the month of May 2024. Till date, the application is
appearing before the learned trial judge. Who are the advocates?
My lord.
Who are the learned advocates for the respective parties?
Respective parties on one side, Mr. Devashish, my lord, and the other side.
Then why are you moving tonight? So told me first this application. Since I'm not inclined to take up this matter.
Suit for declaration and injunction. Plaintiff petitioner is before your lordship, my lord. My lord, initially an order of injunction was not granted, following which, my lord, an appeal was preferred by the plaintiff petitioner, my lord. The Honorable Division Bench of this Honorable Court, my lord, by passing judgment and order dated 17 February 2025, had disposed of my first miscellaneous appeal by granting an order of injunction with a specific liberty to the opposite party number 1 to file a written objection to my injunction application if not filed within a period of 3 weeks. But that period of 3 weeks had got expired on 10th of March 2025. Following which on 20th of March 2025, an application was taken out by way of put-up application before the learned trial court, with a prayer to forfeit the right of opposite party number 1 to file written objection. I should also submit, no written objection to that application was filed. No separate application for enlargement of time was there. But despite there being an order of specific order passed by the Honorable Division Bench to file written objection within 3 weeks, and that not being compliant with the learned trial court had rejected my application. And my lord accepted the written objection, my lord, filed, which is much beyond the time, my lord, indicated by the Honorable Division Bench. My lord, may I take, my lord, the order passed by the Honorable Division Bench, which is at page number 61. Now, the operating portion is at page number 74, para 39.
Page number
74, para 39. The respondent number 1 shall file its written objection to the injunction application in the trial court. If not,
now show me the impugned order by which it was allowed.
Yes, my lord. My lord will kindly see the last third paragraph from bottom, my lord.
There is substance in the
In this matter, Mr. Debabrata Mondal is appearing on behalf of the petitioner, my lord. He could not come to the court due to some family issue, my lord.
But I have the instruction to appear for the opposite party number 1.
My lord. Or after vacation, my lord. As your lordship please.
Yes, serve a copy. The petitioner is directed to serve a copy of this application upon the learned advocate for the opposite party.
One. 51, my lord. I am for the opposite party.
There are some fixed matters.
I apologize, Your Lordship. This item number 51, Your Lordship. Your Lordship. No, item number 51, if Your Lordship is kind enough to keep it after vacation, Mr. Shuddhashatto Banerjee is appearing in this matter. There was a caveat. We've served them just some time back. If it can be kept after vacation.
But tomorrow,
Where is
this
the
matter will be
caveat?
taken up because only difficult I am telling this matter is running since 1984. One round your lordship has already been pleased to hear, and that is absolutely an abusive section 47 application which has been dismissed by the
So that Your
learned
Lordship,
trial
on the
judge.
merits of it, Your Lordship can consider. Let
But you
it.
can take
let
up
it come.
tomorrow. I don't have any, but
That is
adjournment
event.
will be
He is
difficult.
objecting.
Lord.
Yes. Fixed matter. Yes.
Item number 66 is some urgency CJM order.
Yes. Where is Mr. Dotto? Rajoshi Dotto. Which matter was?
He was appearing in item number. He's leading me in item 444, my lord.
444.
I'll start, my lord. He'll be on his way. I've informed him.
444. What is the urgency?
Urgency, my lord, is there is an order, my lord, directing me to make payment by the DRT. I go before DRAT. Now I've come before Civil Divisional Court. During the pendency, my lord, they have filed an execution petition before the DRT. DRT has directed to make payment, my lord, within a period of 30 days. 30 days expires, my lord, during the vacation. That is my most important thing, which is not been hearing. Yes, is that opposite party, my lord? Yes, I've informed, my lord. When I mentioned the matter, can 1 is my restoration application. Can 2 is, my lord, an application for urgent hearing because of the development, my lord.
So when it was dismissed for default?
My lord, dismissed for, I'll
January.
January.
No, I filed within 30 days. I
mentioned that.
The matter was running in the list several times. I have, my lord, mentioned.
Today you have the urgency.
No, because of that, my lord, I mentioned matter did not come up after the development, my lord. Then I file an application also, bringing on record these. Unless and until, my lord, their hands are stayed for a limited period, my lord, my civil division will become infructuous.
Not the issue, my lord, I'll tell you.
Yes.
I was the
Lord,
auction
may I just, my
purchaser.
lord, may I just,
My lord, kindly visualize. I was the auction purchaser. My lord, suppressing the fact that the surface application was pending, the property was sold. I sought for refund by filing section 17. Section 17 court held in my favor. The DRT affirmed the order against which the principal civil division application lies.
Lord, may I just indicate, my lord? My lord, there was an e-auction sale that had taken place. In the e-auction sale,
What is the order and what is the order impugned in the civil division application?
The order, my lord, passed by the learned DRAT. Page number 56, my lord. Starts from 55. Page number 55 of my CO. 31st of January.
Page number
55, my lord. 55 it starts.
14 of the Calcutta.
14.
Yes.
কিছু না, rotation করছে। Yes, may I have your lordship kindly, my lord, Mr. Doctor.
My lord, after the DRAT's order, which lordship just now saw, my lord, there was an application taken out by the bank, by the my learned friend's client, auction purchaser, before the my lord DRT for enforcement of the order. My lord, there is some urgency, that's why we were troubling your lordship. Kindly takes my lord the
But
can
the
application.
urgency was not there when the civil division application was dismissed for default, Mr. Datta.
My lord, I will indicate. Petitioner, my lord, advocate appearing for the my lord petitioner, my lord by mistake said he was appearing for the respondent, got his own petition dismissed for default. My lord, mistake on our part. My lord, the client should not be penalized for that. I am at your lordship's mercy, my lord, to that, my lord. Kindly, my lord, takes my lord the application once, my lord, which we have filed. Can that's page 108 of that application. Can Can 2, my lord.
Can 2.
Yes, there is an order passed by the my lord tribunal now on the enforcement application which has been filed. 102, my lord, the order starts.
102.
Yes.
Can 2 কোথায়?
Order separately.
Can 2 টা কোথায়?
My lord, I have the order separately also, my lord. Lordship permits me, my lord, to
No, this is the subsequent cause of action.
No, this is the order enforcing, my lord, the directions contained in the order of the DRT, which was dismissed by the order of the DRT. Because I am now, my lord, required to, in terms of the DRT order, refund the money with some interest. That was challenged before the DRT. DRT has dismissed the appeal, against which we have come up before your lordship.
So move your civil division application. Let me see what.
Yes, my lord. Kindly takes the civil division application.
So if that is gone, everything is gone.
Yes, yes. If that is gone, my lord, go.
Yes.
Then I don't have a case. My lord, kindly comes to the auction notice, which is at page.
এটা দিয়ে দিন।
The auction notice, my lord, I have to, my lord, because it's illegible, my lord. Kindly seize from this, my lord, legible copy. I have a copy there. My lord, the point which has been
difficult to read. Mr.
No, I will, my lord, assist, my lord. Kindly seize at the, my lord, top.
Mr. Datta, there are two things. When you issued this auction or published this auction notice, admittedly there was a surface
application pending.
Did you disclose that fact in the auction?
My lord, it's not there. Question is, my lord, whether a proceeding pending between the two parties is an encumbrance on the property. This is the question, my lord, which according to me has to be answered.
There are
in the auction notice.
Also, Mr. Datta, please come to the your conduct is also not very good.
No, I will come to the
try to mislead the tribunal or the appellate tribunal, if I can see. So,
My lord, may I
this was the
stage wise, may I come from the auction notice? First, let me just satisfy your lordship.
Is not good. Please kindly come to page 58, paragraph 12.
58. Lordship is looking at the DRAT order.
Civil division application, yes, DRAT order. Page 58, paragraph 12. Page 58 of the civil division.
Yes, my lord, I am there. My lord, I am there.
Place that.
An order was passed by learned DRT2 Kolkata on 21st June 2022 in IA 776 of 22 and IA 777 so arising out of SA, wherein a categorical statement was made by the counsel for the bank that no sale was conducted on 31st May 2022.
You have made this categorical submission.
My
which
lord,
was found. No, I am not saying you.
No. I am on the person who was representing the bank.
Yes.
I'm only trying to, my lord, justify the conduct. I am told, my lord, that it was a wrong statement made by mistake because the sale definitely happened on 31st May. Lordship will possibly, Lordship will not go by that statement today, my lord.
Yes. Mr. Dotto, an order is passed on the basis of a submission made by the learned advocate.
No, but this order was not, my lord, only on the basis of this statement.
One of the reasons.
No,
One of the reasons.
DRT appeal dismissed. It's not that I got a benefit out of the DRT, my lord, the appellate tribunal. I did not get, my lord. This statement, according to me, it's a wrong statement, should not have been made. I will not, my lord, try to justify a wrong statement made by a counsel or an advocate in court. But, my lord, I ultimately lost before the DRT on a different ground, not because of this statement. So, for the time being, kindly, my lord, ignores this statement and, my lord, permits me to place the auction terms once. My lord, kindly comes back to the auction notice.
Yes. It is under which serial number? There are many serial numbers.
No,
here.
before that, at the top, lordship will see, my lord, the heading sale notice for sale of immovable property, movable property. Then, in the bold portion where the date and time is mentioned, kindly see date and time of e-auction. Date is 31st May 22. Time so and so from 1 p.m. to 3 p.m. with unlimited extension of 10 minutes for each bid. The next, my lord, line, property inspection date. 23rd May 2022. So any prospective buyer or auction purchaser who, my lord, intends to participate in the process has the right to inspect the property first and then participate on 31st of May.
What he will know from after inspecting the property?
Whether, my lord, somebody is in possession of the property or not. Whether, my lord, one of his contention was that there is, my lord, somebody on, it's a building. There's somebody in occupation of the property, though it is, my lord, on as is, where is and whatever there is basis. He possibly would not know of the pendency of the essay.
Expressions have been interpreted. What is the meaning of as is, where is, as is, I think.
As is, what is, wherever is.
Yes. Many expressions, those have been interpreted by the Honorable Supreme Court.
My lord, I am also not joining issue there. It's interpreted. I am trying to, my lord, take benefit of this expression, property inspection date, that he was not at dark. The auction purchaser was not at dark. He could have, my lord, inspected the property and realized what is the present position of the property, qua position. Now, my lord, with regard to the property, serial number 2 is the relevant property.
Yes.
Kindly sees the description is given, the amount is mentioned. After that, double-storied residential building standing in the name of Govindur Prasad Kundu at so-and-so, holding number so-and-so, measuring 6.80 decimal, property under symbolic position. So, bank was having symbolic position. This was there. Now, my lord, after that, the sale was held on 31st of May 2022. My lord, in terms of the, my lord, rules, first, my lord, in terms of the auction, my lord, notice 25% was paid. My lord, 15 days time is the, my lord, time period for payment of the balance 75%. This can be extended up to a maximum period of 3 months at the discretion of the bank. My lord, they write a letter requesting for extension of time on 10th of June 2022. They don't raise any objection that I was in the dark regarding the encumbrance of the property by reason of a essay being pending before the DRT. On 10th of June 2022, they seek extension of time to put in the balance 75%. My lord, bank considers that and my lord issues an email on 13th of June 2022 permitting them time till 30th of June 2022 to deposit. My lord, this is the email, my lord, which was issued in.
All right, what happened after that? They have deposited.
No, then they write this letter, which is at page 50. Lordship will now come to page 50.
Yes. Yes, page 50.
Second paragraph. In the meantime, before depositing said 75% of the bid amount, my client out of own interest had been to the spot of the bid property to have inspection, but reaching there nearby, my client had to meet worse experience while owner of the bid property, who was found in constructive occupation there, started chasing my client aggressively, from which my client understood that although you have made sale confirmation in favor of my client, yet physical possession of the bid property has not reached within your within your hand, although you are calling upon my client to deposit rupees 87,50,000. So my client issued a letter to you praying for 3 months of time for depositing the same. So my lord, two things, my lord, emerge from this paragraph. My lord, he goes for inspection, my lord, after my lord the sale confirmation. He does not, my lord, avail of the, my lord, opportunity provided for in the auction notice.
Mr. Dotto, without interrupting you, what is the purpose of auction sale?
My lord,
what is the purpose of a holding auction sale?
To realize, for the, my lord, in the eyes of the bank, to recover the dues as much as possible to set off against the debt of the borrower.
And what obligation you have to the person who is paying that amount?
My lord, my obligation is to set out in the auction notice the terms and conditions on which I am going to sell.
Realize the money from him and you will ask him to chase against that person.
No, my lord, I did not keep him in the dark. My lord, if I had not offered.
Mr. Dotto, this is a deliberate suppression in the auction notice. Yes.
My lord,
you will extract money and then you will say, yes, why did you not inspect that property? Someone else was in possession.
My lord, how can that be, my lord?
Don't put a property on auction sale which is not in your possession, which you cannot deliver to the auction purchaser as on the date of auction.
My lord, I had symbolic possession of the property. It's indicated in the, my lord. It's not even his case that I cannot.
Mr. Dotto,
my lord will not take this.
A surface application. This is should not be allowed, Mr. Dotto.
My lord will kindly.
Extracting.
No, it's not that.
The auction purchaser, he will sit in an air-conditioned chamber and the auction purchaser will run away.
No, my lord, it's not like that. My lord, it's not that I did not give him notice to inspect the property. My lord, he had notice.
Forfeit the amount, pay it to him. Don't forfeit the amount. You put it on another auction sale. Don't forfeit the amount. Yes. Please return it because suppression was there. Deliberate misstatement to mislead the court was also there.
My lord, if lordship is going by the suppression, possibly I cannot, my lord, have an explanation to offer regarding the suppression of the essay.
Yes. You can sue the learned advocate.
No. Question is, the question is whether, my lord, pendency of a essay per se without an order of injunction on the property, my lord, whether it would be an encumbrance on the property.
No. You please refund. You cannot forfeit for that.
No longer
Can it rely upon an Andhra Pradesh judgment? I know, my lord.
I know Andhra Pradesh.
Mr. Dotto, you cannot forfeit in that way.
My lord, he knew, my lord, about the proceeding. He asked for 3 months' time to, my lord, pay the 75% money.
This is only in a way to extract some money. So someone has defaulted. You are putting it for auction, realizing some money.
I have the obligation to make over the property to him.
The possession.
I will make over the possession to him.
Please assure this. File an undertaking.
My lord, under the Surface Act,
you will be happy with that.
Under the Surface Act, I have, my lord, section 14, my lord. Section 14 powers are there.
Yes.
My lord, I can.
How much time you can deliver possession? Do that. Mr. Bordon, you want the property?
Agreeable.
Yes. Please hand over the possession to him.
They will not be able to.
Either you hand over or that cannot forfeit. Return it to him. He cannot be allowed to chase you and the person.
My lord, after my lord, after
forfeiting you cannot do.
No, after my lord, the rules of the game were, my lord, made known to him. After he participates, knowing fully well the rules of the game, can he now say that change the rules of the game?
With this conduct, you cannot be permitted. Either you hand over the possession. That's your obligation. Please hand over the possession to him. Ensure that he gets possession.
That would be altering, my lord, today the terms and conditions of the auction sale notice. My lord,
don't alter. You cannot forfeit. Give it back to him. He does not want the property. You cannot forfeit. cannot get yourself enriched
My lord,
by
he-
holding property. Mr. Datto.
My lord, he kindly comes to, my lord, let me just complete this letter, my lord.
Mr.
Page
Datto,
51.
Mr. Datto, you will feel the pinch when you are sufferer. Legal points, yes, all right.
My lord, that every day, my lord, we realize, my lord,
Yes,
what is the
yes,
client's
yes,
pain.
Yes.
And we thank God that we are not in the shoes of the client. That we realize.
Forfeiting, it's not a case where you can forfeit. It's not a case where you can forfeit.
My lord, gives
Considering your
gives
conduct.
me, my lord, 30 seconds.
Or Mr. Datto, you can take a larger time. I can keep it tomorrow under the 18 we mentioned. Either deliver possession in favor of him or refund the amount, whatever way you want to do. And Mr. Bordon, if he can give possession, you have to pay the balance amount.
Yes. Provided he can give me the possession. Provided.
No, if he gives possession, you have to pay.
My lord, I can come back with that instruction, my lord, tomorrow. My lord, only instead of my lord, tomorrow, my lord, first 10:30, there is some difficulty on my part.
See, day after
My lord,
tomorrow, I will not be there.
No, day after
Day after tomorrow, 10:30, lord,
No.
both of us will be there, my lord.
No, not day after
Then
tomorrow.
10:30.
Then tomorrow 2 p.m.
No, 2 p.m. Tomorrow 4 p.m. my lord. Tomorrow 4 p.m.
Tomorrow 4 p.m.
or before lordship rises, my lord, gives us, my lord, this.
By 10:30, you have difficulty.
My lord, I will be addressed.
How much time that will that matter will continue?
I have some difficulty first half.
My lord, day after tomorrow, 10:30, not more than 5 minutes to be
No,
mentioned.
not day after.
My lord, to be mentioned.
Then vacation bench.
No.
Then vacation.
No. My lord, I am suffering because of this order. That
Appear
requires
tomorrow, subject to convenience.
2 p.m.
2 p.m.
Will appear 2 p.m.
Mr. Datto, 2 p.m. tomorrow.
1:15. 1:15 could be.
1:15.
Yes. My lord, let me just complete this page, my lord, 51. That letter will be complete because I want to show this page.
No further argument. No further argument. Either this way, give him possession. He will have to pay.
No.
You also have to pay.
Tomorrow I will not make further argument, but let me just complete this paragraph. 51, one paragraph for my satisfaction.
Yes.
Last para. In the above juncture, I, for and on behalf of my client, call upon you to extend further time for depositing the rest 75% of the bid amount by my client till providing physical possession of the bid property smoothly in favor of my client.
Yes.
And please note that my
entitled. So you will take the entire money and he will run after you. Right?
It is his, my lord, it is his letter. He is saying that give me extension of 3 months. I will give you 75% in lieu of possession of the property. This is what he is saying.
Yes. How soon can you give him possession? He will have to pay on that date. You give him possession, he will pay on that date. Give possession, take payment, same day. I will not allow Mr. Bordon to take further time. Then your earnest money will be forfeited.
Yes. We'll pay and we'll take it. Because my
one hand you give possession, other hand
1:15. Tomorrow 1:15.
1:15.
Restoration also tomorrow. Everything tomorrow.
Otherwise, lordship cannot dismiss, my lord. My lord, it's very my lord, it's very embarrassing for the junior, my lord. He was appearing for the petition and he himself said I appeared for the respondent. Kindly, my lord.
Doctor, restoration, I am saying it will not be a difficulty, but not today. It has to be, cannot be in a piecemeal way. After some argument.
Before my lord rises, kindly takes it up. CJM order. CJM order. Section 14, surface.
Yes.
DRT, DRAT, both have held against me, my lord.
Tomorrow.
Oh, today. 66 item number. Before my lord rises, kindly takes it up.
Because Mr. Bordon, I tell you, I have to rise sharp at 4:30 today.
Then my lord, can takes it 4:15 then. Some urgency, my lord. Both the DRT and DRAT have held against me.
Cannot conclude. I cannot pass orders within 5 minutes. That is why
I'll keep it tomorrow.
I do not have any difficulty in, but today I have
Then
not only because of Mr. Dotto, he's nodding his head.
No. I appreciate
some other.
Appreciate. I know what. Then keeps it
Not
tomorrow.
that only.
I appreciate everything.
That is one of the ground, but yes.
Then my lord, tomorrow 2 p.m. my lord.
Because another bench also, my lord, indicated the same thing.
Then my lord, tomorrow 2 p.m. my lord. Some urgency, my lord, tomorrow. This matters some urgency, my lord. CDM order, my lord.
Item number
66 of today's list.
Item 66 টা কালকে ফিক্স করে রাখুন। দেখবো ফিক্স করে রাখুন তারপর টাইম Mr. Bordon will be flexible. I know
From 2, I'll be online from 2. First half I'm there. From 2 o'clock I'll be at by law.
Yes.
Item number 50.
Don't scratch your head. There is nothing left in there. You are scratching.
Item 56, my lord, of your lordship's today's list.
56, yes.
Yes, my lord, I am for the respondent in that matter.
But I am there for the petitioner, my lord. I appear for the petitioner, 56.
Yes. What do you want?
Lordship would recall, my lord, in a matrimonial suit, my lord, a direction was passed by the learned trial by 13 DJ Alipur, my lord, directing.
But may I move the application? My lord, it is very, my lord, I am making a very innocuous prayer. My lord, I am in default. Lordship had earlier, my lord, Lordship had entertained my their civil revisional application, directed me to file my affidavit of evidence within 15th of July 2025. Affidavit of evidence of the DW2, which was a matrimonial suit. I am the wife. DW2 was my father. Now, my lord, on 15th of July 2025, I could not file. I made an application before the trial court seeking for an adjournment or a further time because the DW2 was sick. Well, that application was not affirmed, not verified properly, so that application was dismissed and the evidence was closed. Thereafter, I took out an application for recalling of that order, which was also dismissed, observing that your lordship had directed to file it within 15th of July. Well, what I am beseeching your lordship is, well, it is ready. Lordship may impose cost upon me. I am in default. I'm agreeing. There's nothing to argue on this.
That the evidence to be recorded on 15th. On 10th, the similar order was passed by the learned trial judge, mirroring your lordship's order, stating that pursuant to the direction of the honorable court, on 15th, without fail, the affidavit in chief should be filed. On 15th, they come up with an application, one-page application, simply praying for time, unaffirmed, without any medical document, anything, stating that Dr. Mukherjee is ill, so he could not come appear before the court today. Kindly grant me an adjournment. The learned court said that since the direction has been passed by the Honorable High Court, I don't have the authority to modify that order. So I am closing the evidence now. That was closed. On 30th, after 15 days, they come up with an application for recalling. Along with this, then they file an application, the medical prescription also, stating that he was ill on 15th. Now, my lord, the order was passed by your lordship on 30th June. But after that, within these 15 days, they didn't have the time to get that affidavit in chief affirmed. But after that, even after that, another 15 days they took to affirm that, and then they filed it.
Yes, is your affidavit in chief ready?
It is ready, my lord. It is ready. I have taken instruction.
Again, there is
the next date.
But next date
today was fixed.
There also again they have prayed for time.
What is the next date fix?
Well, next date fix, I have not recovered. The order has not been dictated as yet, I am told.
Where is your affidavit in chief?
Well, I am told it. Well, my colleague is supposed to be there in court. Well, Miss Mukherjee, I am told it is ready. I have taken.
Lord, I'm assisting sir, my lord, taking leave from my senior. May I submit this? My lord will perhaps not entertain this application because in effect what they have done, they have challenged my lord's order by way of revision instead of what they could have done, my lord. If they could not file it.
Order in revision where?
My lord has passed an order on 30th of June 2025. By that order, my lord has
fixed the time. Where they have challenged this?
Here only. This application, my lord, kindly sees, my lord, what they have done.
That order they have challenged.
My lord, see that order, my lord.
Will it come tomorrow? Which item? 56.
56. But will it be your lordship's pleasure to keep it on?
করে রাখুন যদি সিরিয়ালি না হয় তাহলে PM
Item number 384.
at 3 p.m. 384, my lord. My client is suffering, but due to the pendency of this civil division, I am for the opposite party father, my lord. My client is not entitled to visit the minor son, my lord. They are citing that the matter is pending before your lordship.
Pendency cannot be a ground.
The trial court is not entertaining my application, my lord.
What is the next date fixed? Can you not come after the vacation?
It is
What is the next date fixed?
matter was previously taken up by your lordship. Mr. Aniruddha Chatterjee is appearing on behalf of the mother, my lord, and they said that probably maybe the matter may be settled between the parties, but it is not settled. But they are not agreeable to see the child to the father, my lord. It is
384.
It is fixed, my lord, at 3 p.m.
It is fixed.
Yes, my lord. If your lordship kindly fix it. Tomorrow, my lord, at any time, my lord, because of
84টা ফিক্সড আছে দেখে দিন তো একটা কটা ফিক্সড ইয়েস চলো আস্তে